Good afternoon. We're going to go ahead and get started. It's 1:34 p.m. And this is the July 25th, 2024 regular meeting for the Seminole County Code Enforcement Board. First of all, welcome. I'm going to give you some information here momentarily, but before we do that, let me ask Madam Clerk to do a roll call for us for board members, please. Here.
Catherine Thompson.
Here.
Mike Simon.
Here.
Dudley Bates.
Here.
Craig Davis.
Here.
Kevin Ross.
Present.
For the record, Don Clears is excused. And Yvette Brown. Here.
Thank you. So we do have a quorum. Next, we are going to do the Pledge of Allegiance, followed by the swearing in of witnesses. So if you're going to testify in any fashion today, just remain standing after the pledge for us, please. Everybody? Pledge allegiance.
To the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
You're going to be testifying, please remain standing, raise your right hand, and Madam Clerk will swear you in here.
Do you swear or affirm that the testimony you are about to give is the truth?
Thank you, and I'll give you some information momentarily. However, I want to suggest that we revise the agenda and go in order to take care of everybody that's here first. And my request for the revision would be starting with case number 19-112 CEB, Miguel and Maria I. Leon, Miguel A. Leon, 1208 Helen Street, Apopka, Florida, 32703. Don't come up yet if that was your name. To be followed, that's on page 2. To be followed by case number 23-36 CEB JCMJ LLC, Christine Crow, registered agent, 1980 Cameron Avenue, Sanford, Florida, 32771. That's found on the top of page 3. To be followed by cases, there's 2 cases with this respondent. It's on page 5. Case number 24-64 CEB Delroy Clayton and Latoya Myers Clayton, 2643 Sand Lake Road, Longwood, Florida, 32779. They have another case that is 24-65 CEB, same address, same respondents. Then to be followed on page 9, the top of page 9, lien request 24-16 CEB, LaChonda Jones, no address, it's an unassigned parcel, I believe. To be followed on the next page, case number 24-24 CEB, Mark and Vivian Severson, 3331 Alena Court, Winter Park, Florida, 32792. They have 3 more cases, same respondent, same address, but those other 3 case numbers will be 24-28 CEB, 24-29 CEB, 24-30 CEB. After we take care of that, assuming this motion, there's a motion for this, it would be the case of on page 14, the top of the page, 24-36 CEB Ruby Smith and Jimmy Smith and Johnny Day Jr., 1254 Depew Street, Altamont Springs, 32701. And then we would go back and start in order for those folks that are not here today. So my suggestion or request is to get a motion to take the cases in that order. Do I have a motion? Yeah.
Mr. Bates made the motion, right?
Mr. Bates, second by Mr. Ross, I think.
Yes, I'll be a second.
Okay, thank you. to take them in the order that I just recited. And with that being said, let me just give you all some information real quick here, and it's easier if I just read it. Thank you. Good afternoon and welcome to the July 25th, 2024 hearing of the Seminole County, Florida Code Enforcement Board. Before we begin, I would like to advise everyone about the procedures that govern appearances before the Code Enforcement Board. This meeting is open to the public under Florida's Government in the Sunshine Law. Therefore, every effort will be made to hear all persons having relevant evidence or arguments to offer. It is required that every person who appears before the Code Enforcement Board needs to register with the clerk if you haven't already done so. The cases where the respondents are present and signed in will be heard first. You'll be sworn in or affirmed by the clerk. If you haven't, let us know when you get up here. I believe you all have. Once all the cases where the respondents are present have been heard, the Code Enforcement Board will hear the remaining cases as they appear on the agenda. When your case is called, please be seated at the table reserved for the respondents. That's this table right up here. The county will present their case, and then the respondents will be allowed to present their case. Additionally, please limit your comments to only information related to this case. Each party may question witnesses offered on behalf of the other party. Additionally, staff members may question those appearing before the Code Enforcement Board. The board will then make their decision based on the evidence and testimony as presented by both parties. All proceedings before the Code Enforcement Board are electronically recorded. Please speak directly into the microphone at the center of the table and state your name before presenting your case. Should you need assistance due to a hearing impairment or a language barrier, please inform the clerk upon registration. All cell phones and other electronic devices are to be turned off or silenced while inside the chambers. Thank you for your cooperation. So that's what you need to know. We're going to call the cases up here in the order we said. Again, you'll be at this table when you're up here. The officer, Code Enforcement, is going to present their case. Please let them present their case. You'll have an opportunity to speak. This board here is going to make a decision, so your comments will be to this board, and they may have some questions for you. With that being said, any other questions? We'll get started. Bringing us to, once I find my agenda again. Starting with the case on page 2, CEB 19, excuse me, case number 19-112 CEB Miguel and Maria I. Leon, Miguel A. Leon, 1208 Helen Street, Popka, Florida, 32703. If you're here as a respondent, please have a seat at the table. And then we're gonna, once you get seated in there, ask you your names. Once you get comfortable there, sir, we'll start with you if I can get your name.
Esther Michelle Helton, daughter.
And I'm sorry, your name again?
Esther Michelle Helton, daughter.
Thank you. And sir?
I'm Ruben Leon, a brother of Miguel Leon.
Ruben Leon, you're the brother of Miguel?
Yes.
You speak English, okay, correct?
Yes.
Okay, excellent. Okay, with that, we'll go ahead and get started. Officer Adair, whenever you're ready.
Code Enforcement Officer Cameron Adair, Seminole County Sheriff's Office South Region. This is case number 19-112-CEB. The respondent is Miguel and Maria I. Leon and Miguel A. Leon. I'd like to give a copy of this PowerPoint presentation to the clerk as Exhibit A. The violation is located at 1208 Helen Street, Seminole County, Florida. The violation charge is Seminole County Code, Chapter 95, Section 95.4, as defined in 95.3B, uncultivated vegetation. The board initially heard, the Code Enforcement Board order was initially on July 25th, 2019. The repeat violation initial inspection was on April 19th, 2024. A repeat letter was sent to the respondents on June 26th, 2024. And follow-up inspections were May 3rd, May 20th, June 17th, June 26th, and July 24th, 2024. The results of the follow-up inspection were the uncultivated vegetation remains. So this is on the initial inspection of a repeat showing the uncultivated vegetation around the property on April 19th. This is a follow-up inspection, May 3rd. The vegetation still remains in the same spots. This was taken on May 20th. There's been no change. You can see where the arrows point, the vegetation still remains. This was on June 17th. They did cut a portion of the property, but the vegetation remains, and that was the day of posting. This was on July 24th, so yesterday. The vegetation still remains. The suggested recommendation by the code enforcement officer is based on the testimony and evidence presented in case number 19-112-CEB. It is determined that the respondent, Miguel and Maria I. Leon, Miguel A. Leon, is or are the property owner of record located at 1208 Helen Street, located in Seminole County as determined by the property appraiser records, is in possession or control of the property, and is in violation of Seminole County Code, Chapter 95, Section 95.4, as defined in 95.3B. It is further recommended that, based on the findings of fact and conclusion and law and order issued on July 25th, 2019, the Code Enforcement Board issue an order imposing a lien in the amount of $4,900 for 98 days of repeat violation from April 19th through and including July 25th, 2024. And the fine shall continue to accrue at $50 per day for each day the violation continues or is repeated after July 25th. This concludes my presentation.
Thank you. Any questions for Officer Adair?
Yes, sir. Is this a result of a new complaint? What's the origin of this complaint?
So the origin of this complaint, the code enforcement officer before me, Dorothy Hurd, brought them to Code Board in 2019, or was this your old case, Kara? It was Kara's case, my apology. So she brought them to Code Board already. It came into compliance. But then recently, back in April, I got another complaint from the county commissioner assistant. So Lee Constantine's assistant, Beatrice Flores. She advised me to do another inspection, see if there's any other violations, and that's how we found it was in repeat.
Any other questions? One or two, maybe. Maybe I missed it, but is it a residence that this is at, or an open?
Correct, residence.
Residence, and it's lived in? Somebody's living in there?
I've never had contact with them, but I believe someone's living in there, yes.
Okay. All right.
And the $50 comes as a result of the prior fine?
Yes,
Right, that was the amount that was approved, so that's why you recommend? Okay.
yes.
One more question. Do you have the date of when this place was brought into compliance from the original complaint? Because it was an action in 19, and then they went before someone and had those reduced to solely administrative costs. Do we know what that date was? How long it took them to get in compliance the previous time when they were out of compliance?
Give me 1 second, I can pull it up for you. I don't have it on hand, but if you want me to look right now, I can.
Yeah, I mean, when they begin their presentation, maybe you could get that information and have it when they're finished?
Okay.
Wonderful.
Any other questions? Okay, this is your opportunity to respond to this. You've heard what the recommendation is, and so that's what we're trying to decide today, what the next step for us is going to be on this case. So the floor is yours. Yes, sir. Thank you.
Thank you. In November 30 last year, we did what is it called? Eviction order in this house. My brother was living in the house at that time, but because of all this garbage and all these things that Jamie J. Leon is the grandson. He's having these bicycles and ladders and things that he wants to recycle and keeps adding. Last 2 months, he put another white truck, I just saw the picture in here, with the front end broken. Those cars need to be moved. The house in the bathroom, you can see the sky. It's no drop ceiling, the roof is going since the storm. Because of that, Maria had to put it in a nursing home. 3 months ago, she passed away in my house. And Miguel, I'm taking him for now for chemotherapy. He has 2-stage cancer. I wanted to put the roof in the house, sell it, but because of the eviction, I can do nothing. I cannot go inside the house. He has a dog in there for 2 years, dead in the freezer in there. There's no water in the house for more than 2 years, and a bill for $2,000 that he broke a pipe or line, and I don't know how to get rid of him. And the authorities haven't done nothing. We have letters. I posted copies of these in the house, and
Let me ask you,
nobody done nothing.
just to get some clarification here, Maria...
She
is
passed
with-
away.
She passed away. And Miguel,
Miguel Leon is my father. He
Your
passed
father.
away.
he passed away too.
Yeah, and my brother Miguel A. Leon is my house, and I'm taking him for chemotherapy right now, and he has a bladder cancer. His son that used to help him in the house passed away last year with cancer, the throat also.
What's that house?
Okay, well, this
And-
was out of compliance once, and then it came into compliance, and now it's out of compliance again. So we're sort of focused on that and trying to get you back into compliance. So that's where we're at. And continue, my apologies, I'm just trying to
No,
get
it's
the
okay.
players here.
Yeah.
Right.
I took my niece, his daughter, and to an attorney, and we have a power of attorney, so we be able to come here. I went to the house. The junk is still accumulating in there. And we have the telephone of his mother in Georgia, and he said, oh, he's in Daytona. No, he's somewhere out, I don't know. I can never see him. I can never see him, and I need some authority to take everything out of there, because actually he's invading a property. That's not his. He doesn't pay rent in there, he doesn't do nothing. My brother allowed him in one limousine that he has in the street park before, he is sleeping there with some dogs.
Well, let's stay focused on, we're here today for the uncultivated vegetation. That issue is what we're here for today,
Yeah,
okay?
it's no way to get inside. Actually, if you try to get to the back of the house, the trees and the bushes, the house is in a living condition. There's no way nobody can live in there. That needs to be cleaned up. But it's no way to get in access in there because he has 2 or 3 cars in there, golf course, a motorcycle, a boat, too many jobs around the whole place. There's no way we can get nothing.
Mr. Simon, you got something?
Yeah, I have a question. So the owner, the only living owner of this home that's listed here is Miguel A. Leon.
Yeah.
Okay, and ma'am, are you his daughter?
I am the daughter, and
We submit the power of
we went in 2003 to do an eviction notice on Tommy J. Leon. He got the letter, he didn't respond. I think we are supposed to go to the sheriff's office, so the sheriff's office can deliver this to him, I believe. We can do that today, and if you would please give us some time so we can evict Tommy J. Leon out of the house, give him some time to move his cars out of the way. before you find us? Because I have death all around me. I lost my brother through throat cancer. My dad has cancer. I don't know if it came from that house. And I don't want to lose Tommy J. Leon, too.
So is your issue is that you have a tenant that was evicted that won't let you have access?
He got the letter because on 2003, we got the, you can have this. 23. This is the eviction notice for Tommy G. Leon to leave, but I don't know if he got served. So we have to go to the sheriff's office to serve him, I believe.
What's the date that you started with this eviction?
November 30.
Back in November last year?
Yes.
30th of November, 2023.
Does Seminole, let me ask a quick question.
Is that going to work? I don't know.
Orange County
We don't
has
know what we're
The
doing.
self-help clerk's office helps them move papers in the right direction. Does Seminole have that, do you know? Don't know. Yeah, don't know, but we can't tell you how to handle your
I know.
internal problem. I wish we could. You may want to check with the clerk's office at Seminole County. Orange County, they have a unit that sometimes helps you tell you what you, but that's a whole separate issue. So we're here today, and all we're going to do is determine how to handle this issue with the uncultivated vegetation. And we're at a late stage here. This isn't a good thing for you all to be in this position because the fine's already gone. It was found in violation in 2019. Somehow got brought into, and it's out of violation again, or out of compliance again. So what these folks here want to hear from you is what your plan is to get this thing fixed and how quick. That's really what they're waiting to hear.
Okay, we're going to the sheriff's office to see if I can get this letter that we wrote to the courthouse to get him an eviction, to get a cop out there to serve him so he knows to leave. I don't know if they did that already, but we got to go and check and then just give us time for Tommy J. Leon to get that service notice so he can leave the house and get his cars and put it somewhere else. My uncle built his home where he lives and he is trying to get him out so we can fix the house, and my dad wants to sell the property.
Can I make an amendment to my earlier statement?
Please.
So on October 24th, 2019, an order was issued reducing the fine to $389.64 to be paid by November 23rd, 2019. The fine will revert back to a lien amount of $3,700 if not paid. The original fine was never paid.
So
So that would be on top of the 98 days of non-compliance as well.
So they were, they came into compliance then sometime between October 24 and November 23 of 2019?
So, or no, so it came into compliance July 25th, or sometime in between July 25th, 2019 and October 24th, 2019.
Okay.
The actual date itself was October 23rd.
Do you happen to know if somebody attended the hearing to get that reduction, or if we just did it because it was in compliance and just moved along?
I could not
That's
answer
fine,
that.
okay. I was just curious. Okay.
All right, and do you currently have any other active cases with this home, or is this only uncultivated vegetation? Because what I'm hearing from this side is that there's a lot more than that.
Yes, so there's a lien on the house or the property for rubbish, and I have an additional case for abandoned junk vehicles that will be brought to the boards in the upcoming months.
That hasn't made it our way yet. Okay, thank you.
Those aren't repeats, those are new?
The vehicles is new, yes.
According to the original order, the respondents were not present
Okay,
at the reduction.
thank you. So the original case, apparently they came into compliance and it was coming up in front of us because it was in compliance. Nobody showed up to ask for that. We just did it because it was in compliance and reduced it to the admin cost if it was paid and it wasn't paid, so.
So, Mr. Chairman, or I guess Officer Cameron, so it's not just $4,900, it'll be the $3,700 because they didn't pay the prior, they reverted back to 37, and then it's $4,900 on top of that.
Correct, so 86 total, 8,600 total.
And then $50 a day as well.
Correct.
for future.
moving forward, yeah. Okay, yeah, Mr. Bates.
Did I hear correctly, you say that this gentleman, some relative, is living in the house now? No, okay. I was wondering about.
Wait, whoa.
You said that-
Tommy J. Leon is in that house, and I was notified by my daughter, he is bringing other people to rent rooms.
But didn't you also say there's no one
And
running
there's
water?
no water in that house, no, because someone tampered with the pipes, and my dad now has a $1,000 bill, and my dad hasn't paid it. And, but I know that the electrical was cut off from my dad's name, and it's put under someone else's name. I don't know, but there's lights in the house.
Thank you. Mrs. Townsend?
I don't have any questions. I'm ready to make a motion.
But, okay, before we move from it, so we can frame the motion correctly, if this is where it goes, the total that's due now, or what are we requesting for a lien?
So requesting for a lien would be the original amount that was not paid, which would be $3,700, in addition to the 98 days of non-compliance totaling $4,900. So in total, it'd be $8,600, plus the lien amount in for non-compliance.
I'm confused here. Was the administrative 389 was paid back in 2019? No?
No.
Was not? Okay, thank you.
Nobody should.
That's why it reverts to the original.
Thank you.
So to clarify, the request by staff is apply a lien, impose a lien for $8,600 and $50 a day going forward for continued violations. That's what staff is requesting, so that's where we're at.
I think that probably more than anybody, I have a history of agreeing with staff. However, I'm going to make a motion contrary to that. I personally would like to see us table this to the August 24th meeting, give these people a chance to evict the people who are illegally in the home, and revisit this at the August 24th meeting.
And I agree with that.
Oh,
Just for clarification, the 3,700 is already in place. There's really nothing that can be done about the 3,700 amount. So really what you're addressing is 4,900.
okay,
Okay, just so we're all clear.
gotcha.
As far as the lien goes,
Right, because that other lien is already in place.
Oh.
As soon as they fail to make that payment,
Oh, okay.
it automatically is in there. So the only thing before you today technically is the $4,900.
Thank you.
So if you're asking for a tabling of the matter, you're just addressing the 98 days, but the amount will continue to accrue at $50 a day, and so that amount will be larger if you revisit this in August. Okay?
and what was the date of?
August 24th at our August meeting.
And I seconded her motion.
You, okay, so we have a motion on the table here to table this until the August 24th meeting.
Just call it a continuance.
Yes.
Just continue the matter.
Yes, and I seconded her motion to continue.
Okay, motion by Ms. Townsend, second by Mr. Ross. Any other questions? All in favor, say aye.
Aye.
Opposed? So that's what we've done. We've given you some more time. You need to get this thing moving, I would suggest. You can do what you want, but August 24th is our next meeting. We simply put this on hold until that meeting. The fine continues. What we'll be looking at when we come back is the staff recommendation of $4,900 lien to be put onto it on top of what's already there, and $50 a day going forward. So that's where this is at. You all know what you need.
Question?
Yes, ma'am.
Is there any way to disappear that? Or my dad has to pay that?
Well, that's a lien that's going to be applied. You could, we have another hearing on the 24th, and you can make whatever request you want at that point.
If Tommy J gets out and we get the Tommy J's cars out of there and my uncle fixes it, can y'all drop the
Let's
funds?
just be clear, because we're focused on the uncultivated vegetation right now. Okay? So the whole Tommy thing and being in there and getting them out, that's all
Okay.
with you all.
Okay. Thank you.
I mean, we wish you the best, but,
Thank you.
yeah.
Thank you.
Okay, and that's what we've done. So if you have any questions, you can speak with Officer Adair after you
Okay.
when he gets through with his presentations today. Thank you for coming in, and wish you the best there.
Thank you.
Thank you. And that brings us to, on page 3, top of the page, case number 23-36 CEB JC MJ LLC, Christine Crow, registered agent, 1980 Cameron Avenue, Sanford, Florida, 32771. And I believe we have an attorney for that case, correct, sir?
Correct. I'm not Christine Crow.
Okay. In your name, sir?
My name is Joseph Kovacic. I'm an attorney from the Lowndes Law Firm.
Okay. All right.
Who does he represent?
Who do you represent, sir?
I represent the respondent here, JCMJ LLC. And for the record, although he's not with me at the table, an authorized representative of the respondent is with me in the room as well, and that's Mr. James Crow.
Okay, and he's what of the representative?
He's an authorized representative.
Oh, I got you.
That's
Okay.
his official
Gotcha,
sort of
okay.
SunBiz designation.
Thank you for that. And let's see. We can, Officer Henson, whenever you're ready.
Code Enforcement Officer Shannon Henson, Seminole County Sheriff's Office, North Region. For the record, submitting this copy of the presentation to the clerk as Exhibit 1. This case is 2336 CEB JCMJ LLC, Christine Crow, registered agent of 1980 Cameron Avenue. The violation is Seminole County Land Development Code, Chapter 30, Part 47, Section 30.882. Concrete crushing is not a permitted use in an M1 zoning district without a special exception. This case was originally heard by the Code Enforcement Board on August 24, 2023, and an order was issued finding the property in compliance. The order stated that there would be a $100 per day fine if the violation was repeated after September 1st, 2023. An affidavit of repeat violation was filed by the Code Enforcement Officer after reinspection on May 24, 2024. An affidavit of compliance after a repeat violation was filed by the Code Enforcement Officer after reinspection on July 22, 2024. The recommendation, based on the findings of fact, conclusion of law, and order in compliance issued on August 24th, 2023, the Code Enforcement Board issued an order imposing a fine in the amount of $6,000 for 60 days of repeat violation at $100 per day from May 24th through and including July 22nd, 2024. I'm asking the board that if the violation is repeated, that they increase the fine to $500 a day for each day the violation continues or is repeated after July 25th, 2024. This concludes my presentation.
Thank you. Reading, it's comply by when? I'm sorry.
They're in compliance right now,
Oh, okay.
but this has been a repeat viation,
Yeah,
and it's
yeah,
only
right.
$100 a day, so we're asking that it be moved up to $500 a day if it falls back out of compliance.
I got it. Okay, thank you.
Can we go back to the photos, and can you explain what's going on at this property?
This was just today. The property is in compliance. It came in compliance on Monday, the 22nd of July. Before that, if we go back one, I think that was, the same day. This was last year. No, that was, this was the second time I went there. I went there May 24th, and they were crushing concrete. And it's not just the tools that they're using right there, but also when they're doing it, any kind of crushing would be considered concrete crushing, because they were using just pounding it at the time before they got the new machine in for the actual concrete crusher. So that was when it repeated.
And the photo right before what we're looking at now was June 28th, I think. June, it was more, yeah, okay.
If she goes back to the very first, all the way from a year
I'm wondering
ago.
what they're doing now that put it back
Yeah, so that was
into-
last year, and then they came into compliance, and then May, this is what they started doing again.
And then June, looked like it was still going on.
Then that's the concrete crushing machine on the right, the brand new one. And then that's July, there's the machine still there. And then that was July 22nd. He I received a phone call that they are in compliance and cleared everything off of the property with that concrete crusher.
Is this
And
an
this was-
open lot there?
It's a construction company,
So there's actually a building, commercial building of some sort? or-
yes, all-terrain.
So I have a question because I'm a little confused. So they're in compliance. You're not asking us to fine them necessarily. You're just saying to increase, if they do it again, instead of doing it $100 per day, to put it at $500. That's what you're asking, but not for, like, the $6,000. We're not dealing with that.
I'm not asking that to be increased, it's just that it falls out of compliance again for the $500 a day.
Well, no, she's asking for the 6,000 for the time that they were in repeat violation. And then if it falls out of compliance, an increased fine to 500.
That's what I thought, but that's not what I heard, so that's
Yeah,
why I
no,
went
two
to make
different,
sure.
yeah, it's two parts of it. So the 6,000 for the repeat time, and then an increased fine if they don't stay in compliance.
Got it. Thank you for the clarification.
Understanding that they are in compliance now, how many times have they been out of compliance?
When I have had this case, that was the very first time they've been out of compliance.
Okay.
Can you go back to, I'm sorry, your first screen with all the inspections, and there's a lot of dates there. There was like 15 dates or something. Follow-up inspection. So those inspections, they were in compliance, or? I'm just wondering how much of a problem this has been to y'all, but I guess that's covered in the 6,000 is,
From what my understanding is, there was compliance in all of the 23 follow-up inspections. Then there's a gap of 9 months, and once they re-inspect in May was the first photo I saw that was non-compliant.
makes sense. Thank you. Anything else before we have the respondents? Okay, sir, I'm going to call you Mr. K because I couldn't write that fast. Sorry, that's it. Sir, this is your opportunity to speak.
May I ask Officer Henson just a few questions? Officer Henson, good afternoon. Did you visit the respondent's property on July 18th, 2024?
I don't have that on record, no, I don't.
During your site inspections, your site visits, your communications with the respondent, have they been generally cooperative in your investigation?
Oh, yes.
So I will apologize, I'm somewhat new to this proceeding, and I was not a part of respondent's team during those inspection dates and the earlier hearings. But what specifically is the text of LDC Chapter 30, Part 47, Section 30.882 that was violated?
It would be a not permitted use unless they had the special exception. So it's not permitted in that zone.
And that's what it says in Section 30.882?
It doesn't say that, but that means it's not permitted. If it says concrete crushing is permitted, then it would be permitted.
Well, let me get clarifications, and I understand his question, and I haven't read that, but it would list everything that is permitted if it was permitted in
Yes.
there? Really? It's got list that long?
It
Okay.
lists the permitted uses, and if it's not a permitted use, then it's not permitted. It's just, if it's not there, it's not permitted.
Okay, thank you.
You'd have to get a special exception.
Hey, Counselor, if you have an example in that code that suggests it says it's permitted, we'd certainly entertain listening to it.
Well, I asked that question because I can't specifically find Section 30.882 in the code. I do see the permitted use table at Section 30.5.2. Is that the source of the violation? It's Chapter 30, Part 5, Section 30.5.2, permitted use table and footnotes. And in that table, it suggests that activity with concrete may require a special exception in an M1 district.
It is chapter 30.5. Section 30.5, what was it? 5.2. Use is unpermitted. It still would need a special exception. Our verbiage has, we just got a new code table, and so our verbiage hasn't changed, just the tables, so the numbers are different.
Thank you very much, Officer Henson. No further questions for you. So, again, my name is Joseph Koshesh, attorney from Lowndes Law Firm. I have a few brief comments just to sort of lay the background. This is a M1 zoned industrial site. It's been industrial, will continue to be industrial in the future. As you've heard, the respondent operates a construction business. The concrete crushing was using old material, crushing it to then use in its business in the future. Business has been operating there for a few years. There's been a lot of home development around the property. Now respondent very clearly understands the requirements for a special exception if it chooses to crush concrete on site. That requirement does not take away the fact that it's an industrial site. So we wanted to go on record that we are here, we are in compliance, we are cooperating with code enforcement, but we very much do plan to continue the industrial use of our industrial property, the crushing activity notwithstanding. I do want to respectfully submit that my client, the respondent, went into compliance on July 18th, 4 days before the affidavit of compliance. I recognize that Officer Henson was not out there. There's no affidavit of compliance. I do have an email, a written email from Mr. James Crow, who has communicated with Officer Henson, the authorized representative, stating that it was in compliance on the 18th. To the extent the board imposes the fine requested, I'd ask it be reduced to $5,600, $5,600 in light of those 4 days. I also want to call into question the fact that the notice for today cites the incorrect code provision. Again, we aren't here to contest the underlying violation, but there is a procedural question with the code provision cited. I am available for questions, but I thank you for your time, and I thank you for letting me make those remarks.
Thank you. Any questions for the respondent?
Has your client applied for a special exception yet?
I do not know.
So,
My firm has been engaged to advise them what they can and cannot do in the property, and we are very clear on what they can and cannot do, though. And I apologize for interrupting you, but...
oh, no, you didn't. But your request was just to reduce the fine to $5,600? Because that's,
Yes, sir.
okay.
Ms. Henson, do you have this? Have you seen this email that he's referring to?
I do not have an email. I got a phone call from Mr. Crow on Monday, the 22nd. I went out the exact day that he called me.
One question, do you have any information you could share with the board as to why, after the first order went out, it came out of compliance for 60 days? What happened with that?
I do not know.
Okay.
I apologize.
I would move to modify, $400 isn't going to kill anybody, so I just move to accept the staff's recommendation as it is, including the increase, because now they have a lawyer, and they should know that what they can and can't do, and let's move forward with the staff's recommendation.
Second.
And that includes the days, the 4 days that may be in question? What's the amount? I'm sorry.
It's $6,000 versus $5,600.
Also, I'd like to make a friendly amendment to the motion, if I could. I'd like to amend the motion to make it ironclad clear which section of the statute in the Land Development Code that has been violated here, because clearly it's not 30.882 as it says on my page.
I don't think that makes a difference one way or the other, because we're not giving legal advice, and we just either have to find them or not find them. So again, I stick with my motion that we just go with the staff's recommendation, and they have their own attorney that can explain to them how to comply with the statutes and stuff.
Okay, staff's recommendation on the fine at $6,000 and the increase for future violations of $5,000.
Correct.
I'll remove my second.
You say you remove?
Yeah, I'm removing my second.
Okay. Is there, and let me try to clarify this. The fine is to accept staff's recommendation as presented, which would be a fine of $6,000. And going forward, violations at $500 a day. We have a motion, Mr. Ross. Do not have a second at this point.
Second.
Second by Mr. Bates.
Before we vote, I mean, I would like to know, I mean, if it's going to go in the record as we're finding them for a part of the Seminole Land Code, Development Code, that they're either not violating or it doesn't exist, I mean, where are we at here?
They were. At the time, this is coming in as a repeat. So at the time it was brought before you, this was the accurate section. It's been brought as a repeat. The testimony was that the numbers had changed. The use scale, the use, I guess what the use chart has changed the numbers, but the actual content has not changed.
That helps, thank you.
Okay? They need to vote? There's a witness that would...
Oh, I'm sorry. Yes, and there were some people that came in too. But yes, whoever the first witness is.
So you have a motion and you have a second.
Okay. I missed the witness.
I'll withdraw the motion so that the people can speak.
I think that's probably best right now.
Withdrawal.
What's that?
You have to vote on the withdrawal.
You have to vote on a withdrawal. Robert's Rules of Order say that we have to vote on a withdrawal.
Well, I can't withdraw, I can't vote, I can't make a motion to withdraw my own, so can somebody else do that? Okay, I move to withdraw my motion so that we can hear further evidence.
I'll second this motion to withdraw.
Okay, all in favor, say aye.
Aye.
Opposed? Okay, so,
Let the witness speak.
who is the
Come on.
witness?
Is this Miss Valerie Bombino?
Yes.
Okay.
Thank you.
And she was
for-
sworn in.
Okay.
Yes, I am. I just made a few notes, and I just want to let you guys know a few things. My name is Valerie Bombino, and I live at 3974 Silver Stream Terrace, which is in the Riverbend community, adjacent to this Cameron property that is in question. I represent several resident homeowners for the past couple of years that are very highly affected by not only the concrete crushing, emitting glass shards in the air, but various other things that are permitted, that are not permitted for the zoning area of the parcels that he occupies. From what I understand, it needs a special exemption to be able to do all of that, and it takes quite a bit of work to get that exemption, because now it is a residential community all the way around all 13 parcels. I just wanted you to know that we have lots of videos, and there's people that, my house actually is about 500 feet away, but there are people that are right butt up against this area, that it is like a construction zone at this place, right in your backyard. And these are really nice houses. And some of them are two-story, and they could see all of this construction and mountains of things, and it looks like a quarry. I just wanted to make this observation known. We have a lot of videos. All of these kind of pictures have been from the people in the neighborhood. So that's what I have to say. Thank you very much.
I have one question. These people
Sure.
bought this house knowing that was there?
No, it was not there. There was just a property
The
there.
construction site was put there after the houses were built? Mm-hmm. Thank you.
Quick question, I'm familiar with at least 3 or 4 river bends in Seminole County. Is this, which, just general area?
The one right off of Cameron Avenue, it's actually, it butts up against his properties, his
parcels,
Okay.
all of that, it's
So
the
you're
one
in
right
a-
off of 46 in Cameron,
Oh, okay. And now I know where 5 of them are, so.
the
Thank
first
you.
one.
Thank you. Thanks so much. Any other questions for the witness? Are there any other witnesses? I saw some people walk in.
No, it's
seeing-
for another case.
Okay. Did they check in? Do I need
Yes.
to? Okay.
Go ahead, you need to now, keep moving, keep
Yeah.
going.
Okay. Are we ready for a motion?
I move to remove, no, I'm just being funny. I move to accept staff's recommendation as we discussed earlier.
Is there a second? Motion by Mr. Ross, second by Mr. Bates, to set status recommendation as presented. In this particular vote, let's do a show of hands. All in favor of this motion, please raise your hand. All opposed, raise your hand.
And then pursuant to Florida statute, section 112.3143, Mr. Davis has to abstain. He has a conflict.
Okay. And he.
So I think
he-
your motion passes.
Yeah, okay, he didn't vote.
He did
Okay.
not vote.
Okay, so the motion, it failed, I thought.
No, it passed
Oh,
3-2.
3-2.
3-2, okay. Oh, yeah, okay, all right. So that's what we did. We accept staff's recommendation as presented. Thank you so much for your time and your input and offering what you did.
Thank you, Chairman.
Thank you. Brings us to our next case, which is found on page 5, towards the bottom, case number 24-64, CEB Delroy Clayton and Latoya A. Myers Clayton, 2643 Sand Lake Road, along with Florida 32779. And there's another case that we'll hear along with that one. And this is also Adair again, whenever you're ready, sir. Ma'am, can you identify yourself?
Hi, I'm Latoya Clayton. I must apologize for my husband. He was not able to make it today.
No, that's fine. Thank you. Yes, sir, go ahead.
Code Enforcement Officer Cameron Adair, Seminole County Sheriff's Office, South Region. This is case number 24-64-CEB. The respondents are Delroy Clayton and Latoya Myers Clayton. I'd like to submit a copy of this PowerPoint presentation as clerk as Exhibit A. The violation is located at 2643 Sand Lake Road in Seminole County, Florida. The violation charge is Seminole County Code, Chapter 95, Section 95.4, as defined in 95.3B, uncultivated vegetation. The initial inspection was on March 7th, 2024. Notice to respondents were sent on March 21st. In April 4th, 2024, compliance dates were set for April 4th, 2024 and April 18th, 2024. Follow-up inspections were March 21st, April 4th, April 18th, July 12th, and July 24th. Results of 2024. Results of the follow-up inspection were the uncultivated vegetation remains on property. This is a picture taken on the initial inspection, March 7th, 2024. Follow-up inspection, March 21st, 2024, grass remains. This is a follow-up inspection on April 4th, no change. This is on April 18th. You can see some of the grass has been cut, but a majority remains. This is date of posting on July 12th. The grass is growing back. And this is yesterday. The grass still remains. However, I did meet with Mr. Delroy. He was on site working to correct the violations. I'm unaware to the grass how its standing is today, but he was removing the other violations for the next case. The suggested recommendation by the code enforcement officer is, based on the testimony and evidence presented in case number 24-64-CEB, it is determined that the respondent, Delroy Clayton and Latoya Myers Clayton, are the owner of record of property located at 2643 Sand Lake Road, located in Seminole County, as determined by the property appraiser records, are in possession or control of the property, and are in violation of Seminole County Code, Chapter 95, Section 95.4, as defined in 95.3B. It is further recommended that the Code Enforcement Board issue an order for the respondent to correct the violation on or before midnight of August 8th, 2024. In order to correct the violation, the respondent must remove all uncultivated vegetation over 8 inches in height. If the respondent does not comply with the order, a fine of $50 will be imposed for each day the violation continues or is repeated after compliance. This concludes my presentation.
Thank you. Any questions for Officer Adair?
How big is the parcel?
I don't have exact measurements, but I'd estimate like an acre.
Has a residential home on it or no?
No, it's just a vacant lot for now. Mr. Delroy said they would like to build a house eventually, but as of now, it's just a vacant lot.
Tell me what the source of this complaint is?
I believe it is one of the nearby neighbors.
Any other questions? Why don't you do the unpermitted one, and there's 2 violations here. We're going to come back and let you respond to both of them. Go ahead and do the, and this is, we're going to jump to the second case, 24-65 CEB, same respondent, same address, appears to be unpermitted use. Whenever you're ready, sir.
Code Enforcement Officer Cameron Adair, Seminole County Sheriff's Office South Region. This is case number 24-65-CEB. The respondents are Delroy Clayton and Latoya Myers Clayton. I would like to submit a copy of this PowerPoint presentation to clerk as Exhibit A. The violation is located at 2643 Sand Lake Road, Seminole County, Florida. The violation charge is Seminole County Land Development Code, Chapter 30, Part 12, as defined in Section 30.202, uses permitted. Storage on a vacant parcel is not permitted use in a R1A zoning district. Initial inspection was on March 7th, 2024. Notice to respondents were on March 21st and April 4th, 2024. Compliance dates were set for April 4th, 2024 and April 18th, 2024. Follow-up inspections were March 21st, April 4th, April 18th, July 12th, and July 24th, 2024. Results of the follow-up inspection, the unpermitted use violation remains on property. Again, this is the initial inspection. These are pictures showing the debris on the property. Those are like cable spools and utility trucks. This is on March 7th. No change. On March 21st, you can still see the spools in the trucks. Follow-up inspection, April 4th, no change. Still has the spools in the trucks. April 18th, this is when they cut the grass, but the storage violation remains. This is data posting. Some of the trucks have been removed, but there's still the spools and the 2 trucks in the background. And this is yesterday's inspection. Mr. Delroy has removed all the trucks but the one seen in the image, but the spools still remain. The suggested recommendation by the Code Enforcement Officer is, based on testimony and evidence presented in case number 24-65-CEB, it is determined that a respondent, Delroy Clayton and Latoya Myers Clayton, are the owner of record of the property located at 2643 Sand Lake Road, located in Seminole County, as determined by the property appraiser's records, are in possession of or control of the property, and are in violation of Seminole County Land Development Code, Chapter 30, Part 12, Section 30.202. It is further recommended that the Code Enforcement Board issue an order for the respondent to correct the violation on or before midnight of August 8th, 2024. In order to correct the violation, the respondent must remove all vehicles and storage from the vacant parcel. If the respondent does not comply with the order, a fine of $100 will be imposed for each day the violation continues or is repeated after compliance. This concludes my presentation.
Thank you. Any questions for Officer Adair? Seeing none, this is your opportunity to speak to these 2 issues. We have 2 issues. One is the uncultivated vegetation. The other is the unpermitted use, which is the storage, those things that are still out there.
Before she speaks, can we ask them, there's been a lot of phone interruptions on the site. Okay, thank you.
Okay, ma'am, this is your opportunity to speak to these two issues.
Sure, I must apologize to the county for those violations, first of all. One, in terms of the overgrown vegetation, we purchased it as basically like that. So in terms of the overgrown vegetation, we were not aware that after purchase, we would have to start keeping it low, because that's how we purchased it. Now that we know, we have taken steps. We have purchased a lawnmower. We have taken steps to keep it low. But as I said, like, we just purchased it last year, and prior to purchasing it, that's how it, like, we didn't purchase it with grass lower than 8 inches. It was all wooded and grown. Two, in terms of the violations, the dates that are there, we, again, apologize for not responding earlier. We get our mail, most of our mail is electronic, and we went on vacation, came back, and noticed that we weren't getting anything at all. So when I reached out to the post office, they said, oh, we thought you moved, so we stopped sending mail to your address, which I didn't know they would. We did a request for mails not to come. So that's why we didn't respond, because we weren't getting any mail. And as soon as I got this, I told my husband and let him know. In terms of the trucks being there, we were not aware that they cannot be there if you don't live there, because other homes in the area does have trucks parked. I mean, not knowing is not saying that, oh, I am right, but again, I apologize. We have since removed all the vehicles, and the property was cut yesterday. And we do have, prior to now, we did contract our persons to come and cut it for us, and we're since gonna get a lawnmower to keep it clean.
Thank you. Questions?
You believe that this will be fully in compliance by the date that's listed
It's
there?
already in compliance. There's nothing on the property. The only thing that it was cut, we used yesterday, a company came and used a drive-in mower to cut it. So the grass is about 2-3 inches tall, if higher, if that high. And there are no vehicles or the spools or anything like that on the property.
Officer Adair, you have anything to add as far as what she just testified to?
I do not.
Thank you. So he hasn't been back since she says it's cleaned up. You're looking for an order in case there's a future violation?
Yes, sir.
That's what we're looking at right here, to find that they were in violation. So staff's recommendation on the uncultivated vegetation is to give them a compliance date, even though she says she's in compliance, of August 8th, or a $50 a day fine going forward. The other unpermitted use, same date, August 8th, or a fine of $100 per day on that one. That's what the recommendation is, taking one at a time. 24-64 CEB, which is the uncultivated vegetation. Is there a motion on that?
I believe Ms. Myers-Clayton wanted to say one more thing.
Oh, I was just going to say, I wasn't sure if you were the one that was there yesterday with my husband. After you left, I believe when you met him yesterday, he was in the process of, he was actually waiting on that company to come and get the grass cut. So they came after you left yesterday. So there's no violation there now.
Okay. So I will have to do a re-inspection just to verify, and then we'll take it from there, all right?
Sure.
Thank you. Anybody have a motion?
I'll make a motion to accept staff's recommendation.
Motion by Mr. Davis, set staff's recommendation as presented. Is there a second?
Second.
Second by Mr. Sinan. All in favor, say aye. Aye. Opposed?
Nay.
And one nay, Mrs. Townsend. So that's what we've done. You've got to August 8th on that. You say you're in compliance, but here's what happens. Just make sure you stay in compliance, or the fines can start right away the second somebody reports it and he sees it. So that's that case. We're doing that.
I just want to ask one more
Go ahead.
question. It was like this for many years. It's someplace that I drive past every day on my way to and from work. And then why now? I'm not saying that the trucks should be there, but why now the rush to get it?
It appears this is when it came to the attention of the county. You know, we see a lot of cases, you sort of inherit whatever you inherit, and unfortunate, but you've got it, sounds like you got it fixed. The next case on this respondent, 24-65 CEB, we've already heard it, man, we're not done yet. We still have one more case for you. If you want to hear it, it's up to you.
Yes, I do.
Okay. Delroy Clayton and LaToya Myers Clayton, same address, 2643 Sand Lake. We heard the case. This one, staff is recommending compliance date. She says they're in compliance of August 8th, same date, or $100 per day fine. That's the recommendation we have on the table.
I'd like to move that we accept staff's recommendation and reduce the amount of the potential fine from 100, I believe it was 100, correct?
Correct.
Down to $50 a day.
That's your motion?
That's my motion.
Okay. Motion by Mr. Sinan, set staff's recommendation as presented, however, reducing the fine if future occurrences are found at $50 per day as opposed to 100. Second by Mr. Ross. Motion by Mr. Sinan, second by Mr. Ross. Any other discussion? All in favor, say aye. Aye. Opposed? Nay. And we had a nay here.
2 days.
Mrs. Oh, okay. And Mr. Davis was a nay. Okay, so it passes, and so you just need to be aware, you come out of compliance again, that's what happens, $50 for the one violation, $100 for the other. And thank you for working on that. Tell your husband thank you, and good luck.
Actually, 50 on both.
50 on 50.
Oh, 50 on each,
Yeah.
50 on each one, I'm sorry, I said 100.
That's okay.
Yes.
All right.
Thank you. Okay, brings us, was that it? Oh, no, brings us, okay, page 9, case number 24-16 CEB, LaChonda Jones, unassigned parcel ID, Altamont Springs 32701, and this is Officer Adair's case again. Officer Adair, whenever you're ready. This is a lien request, by the way. We've heard the violation on this already.
We good? Code Enforcement Officer Cameron Adair, Seminole County Sheriff's Office, South Region. This is case number 24-16-CEB. The respondent is LaShonda Jones. I'm going to submit a copy of this PowerPoint presentation to clerk as Exhibit A. The violation is located on East Altamont Drive in Seminole County, Florida. The violation charges Seminole County Land Development Code, Chapter 30, Part 11, as defined as Section 30.182, uses permitted. Storage on a vacant parcel is not a permitted use in an R1 zoning district. The initial inspection was on October 5th, 2023. The code board order date was on June 25th, 2024. And our follow-up inspections were on April 29th, June 25th, and yesterday, July 24th, 2024. Results of the follow-up inspection, the unpermitted use violation remains on property. So just a refresher, this was a date of initial inspection. These are photos showing the debris in the back on October 5th, 2023. These are follow-up inspections on April 29th, 2024, so this is after the hearing date, working towards compliance. More pictures from April 29th showing Mr. Jones trying to clean up the violation. This is on June 25th, 2024. This is the, I believe when the order date was. You can still see the rubbish. There's Mr. Jones again, or this is a pic, pictures from yesterday. Follow-up inspection before the hearing. You can see Mr. Jones still removing the debris in the back. A lot has been removed. I can give him credit for that, but a lot still remains. These are more images from yesterday's inspection showing the rubbish out front. The suggested recommendation by the code enforcement officer is based on the testimony and evidence presented in case number 24-16-CEB. It is determined that the respondent, LaShonda Jones, is the owner of record of the property located at East Altamont Drive, located in Seminole County as determined by the property appraiser records. Is in possession or control of the property and is in violation of Seminole County Land Development Code, Chapter 30, Part 11, Section 30.182. It is further recommended that the Code Enforcement Board, based on the findings of fact, conclusion, and law and order, the Code Enforcement Board issue an order constituting a lien in the amount of $3,100 for 31 days of non-compliance from June 25th through and including July 25th, 2024, at $100 per day, and the fine shall continue to accrue at $100 per day for each day the violation continues or is repeated after July 25th. This concludes my presentation. Oh, I'm sorry. Next slide. Oh, yeah, this concludes my presentation.
Thank you. Any questions to Officer Adair?
Officer Dare, if you, do you have a concept of what percentage of the junk has been removed?
I do not. After inspection yesterday, the initial inspection photos showed the large junk pile, but after seeing it removed, there's more violations behind it. So it is a vacant parcel still, so nothing could be stored on it. There's still cars, tarps, tents, etc.
I have a question. Remind me, this is the property behind the barbecue place?
Correct. Behind it used to be Popolanos Mexican. I think now it's something else.
Okay, well, I can make sure. Thank you.
Any other questions?
For the record,
yes, sir.
it's La Lechonera currently, they just opened.
Okay.
Okay, Mr. Jones or daughter, it's your opportunity to speak to this.
He wanted to let you guys know that he's actually been working hard to clean it up. Please take into account that this property, he has had this property for over 45 years. So this is not just stuff that just appeared there like over time. This stuff has been there for 45 years. So he's doing like everything he can do himself because he's the only person that's cleaning it up. So he's doing everything he can do himself to get it done. He said he was told that he had 6 months to get it cleaned.
No.
What did you say?
You give me 3 months. I asked for 6 months.
Okay, he asked for 6 months, and they gave you 3 months. And they gave him 3 months. But like I said, he's doing his best to get it clean. You asked for a percentage. It's a huge percentage compared to what was there before, you know, so it is a big difference. But I mean, he's doing the best that he can.
Because, like I said, I've been doing this hemp back there for 45 years.
Yeah, I told him. Yeah, he's had the property for 45 years.
I thought I was grandfathered in. I didn't know it was a code violation what I had, because I've been back there for 45 years.
He said he was under the...
I had control of that property for 45 years, and for a junk and everything, it's not a business. It's my living.
And let me ask you, I'm sorry, sir, go ahead.
It's my living. And what I say, I go out and pick up stuff, and people bring it. I don't buy nothing. I pick it up and bring it back and process it and take it to the, and sell it to the cycle place.
Right.
It's my living. And like I say, I knew I couldn't do it in those 3 months to clean it up no way. That's when I asked for 6 months.
Well, it leads me to my question. I remember the case, remember you were here last time, and I had thought, my question was going to be, because I thought you said it was because you're scrapping activities and it helps you make a living. That doesn't look like scrapping stuff to me.
Oh, that's all scrapping stuff. That's actually
Those plastic bags
the stuff that you see in the bags here are plastic, are cans.
Well, see, I bring that in every day,
and I process it and get called.
Okay.
That's given to me every day. I go and pick them up at the factory, where they, at a place where they make drinks. Now that right there, tomorrow he'd be gone.
Yeah. Okay. It doesn't justify whether it's something or not that you're scrapping. I'm just curious.
No.
Something to take into consideration.
Yeah, but that is what exactly in those bags. That
Okay,
is
I understand.
cans.
Makes sense.
Yeah.
Anything else? They may have some questions.
I have a
Mr.
question for
Davis.
the officer. Besides these violations, once again, is this even a permitted use in this zoning district to be scrapping?
It would not be a permitted use, no. It's a residentially zoned area, and you can't do that in a resident.
This property is zoned residential?
Correct.
On Altamont Drive?
I mean, it's entirely bordered by commercial property,
Correct.
so.
Excuse me.
Go ahead, sir.
My mind goes in and out. But, go ahead.
Sir, all we're asking for is more time to get this done, you know?
Can I say something?
Yes, ma'am.
The problem is, if he continues to do it, it's never going to go away. It's never going to
Understandable.
stop, right? Based on what I'm hearing is, if he keeps trying to do what he's trying to do, it's going to continue to be a problem.
I understand that too. What he's saying is that, like he says, the stuff that's there, like you see now, he said will be gone tomorrow. Basically, what he's trying to do is get the stuff that's been there for all of these years, you know what I mean? This stuff, okay, yeah, granted, it's an issue, but that in the grand scheme of things, that's not the biggest issue at hand, you know what I mean? As far as these cans being out here, he has a bigger issue in the back that he's trying to clear up, you know what I mean?
No,
I'm trying to
I hear
explain
you.
it the best way I can.
And you're
I'm
doing a
sorry.
good job, but you have to kind of make him understand
Oh,
that the
absolutely.
cans coming in are going to continue to keep you out of compliance, correct?
Correct. And I
Okay,
also-
okay,
Yeah.
absolutely.
Unrelated to this case, I have a open case on his actual residence where he has 2 RVs and a vehicle that are inoperable. Yes.
May I speak on that?
And I was told by, I'm sorry, what is your name? She said they were going to bring the RVs to the lot and just store them there to clear up the violation. So it's not going away.
We're not to hear that, Kate, but we do consider other events, and that
But
may
you're
be
not
later.
here to
Yeah, maybe
discuss
later.
that.
We're not talking about
Okay,
that.
thank
We're
you.
talking about whether or not there's going to be a lien today applied as a result of the March date when y'all were here. I think you both were here. And you were given a time to fix it, and it's not fixed. And now we've heard testimony, there might even be new stuff coming in. So we're trying to determine a lien, whether a lien needs to be applied and how much. Any other members have questions? Motion, the request is for a lien of $3,100 for 31 days of noncompliance to continue accruing at $100 per day. That's the request. Floor is open for Ms. Townsend. Do you have something?
As I recall, in our last meeting, we discussed this being a health safety issue. And in that regard, I would make the motion to go along with staff's recommendation.
I'll second that.
Motion by Ms. Townsend, second by Mr. Davis to accept staff's recommendation as presented. Any other, Mr. Russ?
There's a question, when you said the health safety issue, what does that mean? I'm not against that, I just don't know what that means.
We tagged it, do you want to explain?
I don't remember.
Yeah, because the fire department, I believe, had said that it was impeding their access to any emergencies. So,
Which that has been cleaned, it's not that way anymore.
right, we understand.
It's just something to remind you. That's a good
okay,
reminder,
that's
but it
what I
doesn't
was wondering.
change what you're doing here today.
Okay, that's.
Give the county a little more authority if nothing happens.
That's all I
So,
said.
yes, sir. Okay, so where were we? Had motion by...
Motion, second by,
A second by Mr. Davis to accept such recommendation as presented. Anything else, discussion, comments? All in favor, say aye. Aye. Opposed? That's what we've done. So the fines are still accruing. The quicker you can get that done, the better. Please communicate with Officer Adair. And thank you for what you've done.
Yeah, I understand. saying. I completely understand what you're saying. It's just it's unrealistic to think that after 45 years of accumulating things, you're going to be able to get rid of it within 3 months. But I understand what you're saying. She's absolutely right about, keep bringing in stuff. You're going to keep accumulating stuff. I understand that.
Right.
But I'm just trying to look at it from a realistic point of view. It's just unrealistic to even think that you can get rid of all of that stuff
But
within that appointed time.
The stuff I'm bringing in, I don't take it in the bag.
Yeah, but
But I'm talking about, like the cans there, that's the only thing I bring in, because I get them free. And when I'm not gonna give up them can call, that's my living. I'm talking about, I get a trailer load of cans a week. That $400-500 a week.
Good
Will you give it up?
Well, you unfortunately,
I'm
you
talking
find
about
different
free. I'm
places.
talking about it's free.
Yeah.
I ain't got to pay for it.
Yeah, but what he's saying is that he's not here to determine that factor. He's here to determine about this lien. So
Good luck.
we understand.
Good luck.
Thank
Yeah.
you.
Thank you. Okay, brings us to, on the next page, page number 10, top of the page, case number 24-24 CEB Mark D. and Vivian M. Severson, 3331 Alena Court, Winter Park, Florida, 32792. They have a total of 4 cases on this same property, same respondents. Whoever's here for that case, I've noted somebody's here. If you can step up to the table, have a seat.
Add these two to the end of your agenda.
Okay.
They're late, so they're after Johnny Day. We'll go back to that one. Number 68 and 69. Go
Yep,
back
here.
to them, yeah.
Okay, sorry. I'm sorry. I'm sorry, folks, give me one moment here. Oh, here we go.
Yeah, he'll do those at the end.
Okay. Okay, whenever you're ready, you can go ahead and, oh, well, let me read it into the record, I'm sorry.
I think you did.
Oh, I did?
Go ahead.
Okay, the Seversons, yes, go ahead.
Tamara Judges, Seminole County Sheriff's Office, East Region Code Enforcement. For the record, I am submitting a copy of this PowerPoint presentation to the clerk as Exhibit 1. This is case 2424 CEB, respondent Mark D. and Vivian M. Severson. The violation is located at 3331 Alena Court, Seminole County, Florida. The violation charged rubbish. My initial inspection was on October 16, 2023. The code board order was on May 12, 2024. My most recent follow-up inspection was yesterday, July 24th, 2024. The results of the follow-up inspection, the violation of rubbish remains on the subject property. These pictures are taken through fence slats, as I'm not able to get in contact with Mr. and Mrs. Severson at times, and this is in their backyard. They have a random wagon, there's some canoes that have been there, and if you look along the fence line, there's pallets. This is also on the other side, and I can only get to a certain angle, but they have stuff around their pool as well. The suggested recommendation by the code enforcement officer is based on the testimony and evidence presented in case number 2424 CEB. It is determined that the respondents, Mark D. and Vivian M. Severson, are the owner of record of property located at 3331 Alena Court, located in Seminole County, as determined by the property appraiser's records, in possession or control of the property, and are in violation of the Seminole County Code, Chapter 95, Section 95.4, as defined in 95.3B. And it is further recommendation that the Code Enforcement Board, based on the findings of fact, conclusions of law and order, the Code Enforcement Board issue an order constituting a lien in the amount of $7,500 for the 75 days of noncompliance from May 12th, 2024, through and including July 25th, 2024, at $100 per day, and the fine shall continue to accrue at $100 per day for each day the violation continues or is repeated after July 25th, 2024. The respondents must contact myself to arrange for an inspection of the property to verify compliance. This concludes my presentation.
Thank you. Any questions for us or judges? Should I go into?
I think I would address
Okay.
one at a time. These are lien requests.
Okay, we're going to take these one at a time. No questions for the officer. Mr. and Mrs. Severson, how do you pronounce? I'm sorry. Severson, thank you. This is your opportunity to speak to this. We have 3 other cases to follow, but this is a request for a lien due to the fact of the days it was out of compliance, and the request is for a lien of $7,500 for the 75 days out of compliance. That's what we're here for. So this is your opportunity, folks.
Well, I am the living soul, Mark Dennis Severson, and this is the living soul, Vivian M. Severson. Just to clarify, this is, all caps, is indicative of a corporation. We are not a corporation. I'm looking at your flag and notice that it has a gold fringe on it. So is this maritime court? I'm just trying to clarify what kind of
This code enforcement. This is an administrative code enforcement hearing.
Okay.
So do you have anything to say with regards to the county's request to lien your property for failing to comply within the time period?
I didn't even hear about the property being, I didn't know if she had the right to go and snoop around in my backyard.
I wasn't in your backyard, sir.
Where you're looking in my backyard,
Sir-
that's called peeping, they
Sir,
call
can-
it a peeping Tom.
Okay.
Okay.
Move on to the
Isn't that
next
a law?
case, which is move on to the next case, which is 2428 CEB. All respondents were previously sworn. Go ahead, Inspector.
Tamara Judges, Seminole County Sheriff's Office, East Region Code Enforcement. For the record, I am submitting a copy of this PowerPoint presentation to the clerk as Exhibit 1. Thank you. This is case 2424 CEB, Mark D. and Vivian M. Severson. The case, this case is located at 3331 Alena Court, Winter Park, Florida. The violation charge is unpermitted use. My initial inspection was on 10/16/2023. The code board compliance date was 5/12/2024. Follow-up inspection was yesterday at 7/24/2024. The results of the follow-up inspection, the violation of occupying a camper remains on the subject property. This was taken yesterday on their street, and as you can see, the camper is popped open and there are piping and things hooked up to the camper. The suggested recommendation by the code enforcement officer is based on the testimony and evidence presented in case number 2428 CEB. It is determined that the respondents, Mark D. and Vivian M. Severson, are the owners of the record property located at 3331 Alena Court, located in Seminole County as determined by the property appraiser's records, in possession or control of the property, and are in violation of the Seminole County Land Development Code, Chapter 30, Part 6, Section 30.102, uses permitted. And it is further recommended that the Code Enforcement Board, based on the findings of fact, conclusions of law, and order, the Code Enforcement Board issue an order constituting a lien in the amount of $7,500 for 75 days of noncompliance from May 12, 2024 through and including July 25, 2024 at $100 per day, and the fine shall continue to accrue at $100 per day for each day the violation continues or is repeated after July 25, 2024. The respondents must contact myself to arrange an inspection of the property to verify compliance. This concludes my presentation.
Thank you. Any questions for us or judges? Seeing none, this is your opportunity to speak to this particular issue, whether or not there should be a lien imposed, and if not, why not, on this violation that we just saw. If we could limit to that. Yes, sir.
I believe I have a constitutional right to life, liberty, and the pursuit of happiness. I believe I'm being infringed upon, and that's part of the Constitution, but it's also predated because it's a God-given, unalienable right. And what she's telling me is I can't use my property for what I want to use it for. And I don't know the Florida code or the Florida statute or the Florida law that gives you the right to take my rights away. And as I'm just challenging the lawful right for her to take away my rights and then charge me for it.
All right, moving on to item 2429, CEB, same property, same respondents. All parties have previously been sworn. Go ahead, Inspector.
Officer Judges, go ahead, please.
Tamara Judges, Seminole County Sheriff's Office, East Region Code Enforcement. For the record, I'm submitting a copy of this PowerPoint presentation to the clerk as Exhibit 1. Thank you. This is case 2429 CEB, respondents Mark D. and Vivian M. Severson. The property is located at 3331 Alena Court, Winter Park, Florida, and the violation charged is stagnant water. Initial inspection was 10/16/2023, Code Board compliance date 5/12/2024, follow-up inspection 7/24/2024. The result of the follow-up inspection, the violation of stagnant or foul water remains on the property. This was taken yesterday again through fence slats, and you can see that the pool is still stagnant. That's me zooming in. The suggested recommendation by the code enforcement officer is based on the testimony and evidence presented in case number 2429 CEB. It is determined that the respondents Mark D. and Vivian M. Severson are the owner of record of property located at 3331 Alena Court, located in Seminole County as determined by the property appraiser's records, in possession or control of the property, and are in violation of Seminole County Code Chapter 95, Section 95.4 as defined in 95.3F. The suggested recommendation by the code enforcement officer is based on the findings of fact, conclusions of law, and order. The code enforcement board issue an order constituting a lien in the amount of $18,750 for the 75 days of non-compliance from May 12th, 2024 through and including July 25th, 2024 at $250 per day, and the fine shall continue to accrue at $250 per day for each day the violation continues or is repeated after July 25th, 2024. The respondents must contact myself to arrange for an inspection of the property to verify compliance. Before I conclude my presentation, Mr. Severson states that he does have a koi pond in the pool, which I said is fine, but the water does have to be clear so that, God forbid, a child or someone or something get back in there, we can see it as soon as possible. This concludes my presentation.
Thank you. Any questions for Officer Judges?
Officer, if any of these cases, has there been any progress on any of these cases?
Any other questions? Thank you. Severson, this is your opportunity to speak to if there's nothing else you have to add that is specific to this lien request, this is your opportunity.
She keeps calling it a pool. It is a pond. I looked it up in Black's Law Dictionary, the definition of pond. It fits it to a T. I have an aerator in it, so it's not stagnant. That aerator runs 50% of the day. Every 15 minutes it's on, and every 15 minutes it's off. It's on a timer. There's fish in it. There's plants in it. It leaks, so I have to put water in it. I put well water into it. So it's not stagnant. I don't know, the fish would die, I think, if it was stagnant, if there wasn't proper aeration in it. And I don't know why she keeps insisting on calling it a pond, or a pool. It's a pond. And I think if you go through Seminole County, you could probably find thousands of ponds that are, you can't see the bottom. The yard is fenced, the patio is fenced. There are no children living there. I
Okay,
mean,
so
well, you could do this for every lake and pond in the whole county.
we understand your contention is it's a pond, not a pool, basically.
Yeah, it's a pond, and fish poop, you know? And they dirty it, I can clean it up, spotless. And in 24 hours, it'll be cloudy. In 48 hours, you won't be able to see the bottom.
Thank you. Mr. Simon, you look like you may have, anybody have any questions? No?
All right, moving on to the last one, 2430, same respondents, all parties have previously been sworn.
Tamara Judges, Seminole County Sheriff's Office, East Region Code Enforcement. For the record, I am submitting a copy of this PowerPoint presentation to the clerk as Exhibit 1. Thank you. This is case number 2430, CEB, respondent Mark D. and Vivian M. Severson. The violation is located at 3331 Alena Court, Winter Park, Florida. Violation charge, uncultivated vegetation. My initial inspection was on 10/16/2024. Code Board compliance date 5/12/2024. Follow-up inspection 7/24/2024, which was yesterday, and the violation of uncultivated vegetation remains on the subject property. These, again, were taken through fence slats, and this is their backyard. The front yard is maintained, however, the backyard is not, and you can see that it is well over 8 inches. The suggested recommendation by Code Enforcement Officer is based on the testimony and evidence presented in case number 2430 CEB. It is determined that respondents Mark D. and Vivian M. Severson are the owners of record of property located at 3331 Alena Court, located in Seminole County as determined by the property appraiser's records, in possession or control of the property, and are in violation of the Seminole County Chapter 95, Section 95.4 as defined in 95.3B. And it is further recommended that the Code Enforcement Board, based on the findings of fact, conclusion of law, the Code Enforcement Board issue an order constituting a lien in the amount of $3,750 for 75 days of noncompliance from May 12, 2024 through and including July 25th, 2024 at $50 per day, and that the fine shall continue to accrue at $50 per day for each day the violation continues or is repeated after July 25th, 2024. The respondents must contact myself to arrange for an inspection of the property to verify compliance. This concludes my presentation.
Thank you. Any questions for us or for judges? Seeing none, we'll take these one at a time. I will say, we need to correct the date. I think the initial inspection should show as 2023 instead of 2024 on the first slide.
Yes, thank you.
Yeah. So we'll go back to 24-6, no, excuse me.
Should we allow the respondent to speak on this?
Yes. This is your opportunity, similar to the other ones. If you have anything to add on this particular request for a lien?
When was that last picture taken?
Yesterday.
And I don't know, I mowed the lawn a few days ago. I don't know, there is some weeds up against the Florida room, what used to be a Florida room before the Seminole County Sheriff and the ATF set off a bomb in it. Now there's glass all over the yard, so I don't mow right up to the edge of it because there's broken glass everywhere. I don't want to scatter it all over. So, yeah, there's some debris up close to the Florida room, but I mowed the rest of the lawn. I've mowed it several times in the past since I've been back. She saw me on the 20th of May, and we were unhooked from our RV for about 3 weeks, and then I get a thing in the mail that says that I am not compliant, and they were charging me, and I said, well, if they're going to charge me, I might as well hook it back up. So I don't agree with most everything here. That I don't know what more you want me to do than mow the lawn. There are a few weeds where I have wood.
She can, you can get with her, and she can clarify whatever you don't understand has been fixed, but we've seen the pictures, so we understand that you don't agree with it.
Can I?
Yes, ma'am. Ma'am, Ms. Severson, did you? Oh, I'm sorry, go ahead.
So the picture on the left-hand side, if you're looking at your house, Mr. Severson, from the back is to the right. That is the back right of your yard, where your canoes and the pallets and everything are piled up. The right is facing towards your pool area.
So what's wrong with the one on the right?
Well, it's over 8 inches, so once a property has been maintained, it has to stay 8 inches or below.
That little heart,
Yeah.
it's over 8 inches. Because I didn't use a weed whacker to go around it. The rest of the lawn is mowed.
All right, so we're gonna-
Unbelievable. I think you're just looking for extra things to throw at me.
Okay, thank you.
I don't think you need to do them individually, Mr. Chairman.
Okay.
I think you could hear,
We'll
you've
do-
heard all 4 of them and make a determination.
Just to recap, we're going to take a vote on these all together. It'll be 24-24 CEB. The recommendation was $7,500 for 75 days out of compliance. Fine would continue $100 a day until in compliance. 24-28 CEB recommendation is $7,500 lien as well, $100 per day to continue as a fine. 24-29 CEB, the recommendation is $18,750 for 75 days non-compliance at $250 a day, and the fines will continue to accrue $250 a day for continued violations. And 24-30 CEB, the final one, recommendation is lien for $3,750 for 75 days of noncompliance, and the lien would continue at $50 per day. That's the staff's recommendation. Do we have a...
But just before we go to motion, I just want to put it on the record that, I mean, we're already up to, if this is approved today, that'd be about $38,000, somewhere in that neighborhood of liens on this house. And, you know, just wanted to make sure everybody understood that before we move forward.
And I would like to ask the respondent just one question.
Yes, sir.
Do you have any intent, you heard what everybody just said in the amount of lien, do you have any intention of working with the code enforcement officer to, I understand how you feel, but there are rules. Do you have any intention of working with the code enforcement officer to correct these things?
I have been correcting things. I mowed the lawn. I don't have a weed whacker that's operating. I mowed it clear up to the edge of the fence. Yeah, I didn't get around that heart very close.
I meant on everything. I heard your arguments that she was wrong. Are you going to work with her on any of the things that she asked? It's important because I want to know that before I vote on such an important matter, if you're going to work with code enforcement or not.
My yard, I used to keep it up very well. My health has been suffering for the last 10 years. I do as much as I can. I work 2 or 3 hours a day, and I'm exhausted. I'm dealing with medical issues, health issues, and
Specifically cancer.
so I do what I can. I used to keep my home immaculate. My son, I rented the house to my son. He's kind of a mess, but he's my son, and I can't always keep up with him cleaning up. So there's nobody that wants it more than I do to have a pond that is clear. That was my intention all along, to have a clear pond. I'd like to see the fish. But so far, I haven't been able to do that. I've had a lot of issues with the pool pump and other things. I utilize the RV probably about 4 to 6 hours a day. We store food in there, we eat in there, and maybe watch a little TV, but we live in the house. I don't know, I keep it plugged in to store the food. I think she's being unreasonable. I'm not hurting anything. I don't believe that we're loud or annoying the neighbors or anything like that. But if I want my food to not spoil, I need it plugged in. Yeah, I'm doing the best I can. But like I said, I can only do so much, and I'm exhausted. I got to go rest. I don't like to go in the house because my son has his friends over. He doesn't, and it's a tripping hazard basically because of all his hobbies and stuff like that. So anyway, we just try to give him as much space as we can. So I want the house to look nice too. I want the yard to look nice too. I want the pond to look nice too. And I'm getting penalized that this kind of money that you're charging me, I could maybe fix it up. Maybe I could do a lot of repairs and everything would be nice, But instead of helping me out, you're penalizing me. You want me to be a good neighbor? You know how they define neighbor in the Bible? A neighbor is someone who helps you, not fines you. Ever hear the story about the Good Samaritan? It was a guy who actually stopped and helped the guy that was beaten up and robbed. That was a parable. So you want to be a good neighbor? You want me to be a good neighbor? You be a good neighbor. And quit finding me and quit finding fault with me.
I move to accept the staff's recommendation as is on all 4.
Second.
Motion by Mr. All, second by Ms. Townsend, accept staff's recommendation as presented on all 4. Any other discussion? All in favor, say aye. Aye. Opposed? Motion carries. So we have went with staff's recommendation. The fines are going to continue to accrue until you get the stuff fixed there. But thank you for coming in, and we'll hope for the best on that. Brings us to Ruby, case number 24-36, CEB, Ruby Smith, Jimmy Smith, and Johnny Day Jr., 1257 Depew Street, Altamont Springs, 32701. Unless you're there whenever you're ready. Sir, could I get your name, please?
Johnny Day Jr.
Thank you. Whenever you're ready, Officer Adair.
Yes, sir.
Ruby and Jimmy Lee, they're dead. Oh, I'm sorry.
We'll give you a chance in here in a minute. He's going to present the case.
Code Enforcement Officer Cameron Dare, Seminole County Sheriff's Office, South Region. This is case number 24-36-CEB. The respondents are Ruby and Jimmy Smith and Johnny Day Jr. I'd like to present a copy of this PowerPoint presentation to the clerk as Exhibit A. The violation is located at 1257 Depew Street, Seminole County, Florida. The violation charged, Seminole County Code, Chapter 95, Section 95.4, as defined in 95.3E, abandoned or junk vehicles. The initial inspection was on December 14th, 2023. The Code Board order date was on June 7th, 2024. And the follow-up inspections were on June 10th, July 12th, and July 24th, 2024. Results of the follow-up inspection, the junk and abandoned vehicle violation remains. Excuse me. So these are on the initial inspection after the Code Board. It shows the vehicles are still there on June 10th. This is the posting for the lien hearing on July 12th. The vehicles still remain. These are more photos of the other vehicles from July 12th. This is yesterday's inspection, July 24th. The truck and the vehicle still remain. And again, more photos from yesterday's inspection, the other perspective of the vehicles. The suggested recommendation by the code enforcement officer is based on testimony and evidence presented in case number 24-36-CEB. It is determined that the respondent Ruby and Jimmy Smith and Johnny Day Jr. are the owner of record of the property located at 1257 Diffuse Street, located in Seminole County as determined by the property appraiser records, are in possession or control of the property, and are in violation of the Seminole County Code, Chapter 95, Section 95.4, as defined in 95.3E. It is further recommended that the Code Enforcement Board, based on the findings of fact, conclusion of law and order, and the Code Enforcement Board issue an order constituting a lien in the amount of $3,200 for 63 days of non-compliance from April 26, 2024 through and including June 27, 2024 at $50 per day. And the fine shall continue to accrue at $50 per day for each day the violation continues or is repeated after June 27, 2024. This concludes my presentation.
Thank you. Could you clarify for me the recommended lien? I've got 4,800 in my, if I'm looking at the right page here, on my page 14, and then $100 a day. You think you said 3,200 and then $50 a day? Maybe no, this is,
Yes, ours, you're correct, that's what ours says.
yeah. I just want to know what they're.
Oh. My apologies. Yes, that should be different. It should be an order constituting a lien in the amount of $4,800
Okay.
for 48 days non-compliance from June 8th, 2024 through and including July 25th, 2024 at $100 per day, and the fine shall continue to accrue at $100 per day for each day the violation continues or is repeated after July 25th.
Thank you.
My apologies.
No problem. Any questions for Officer Adair?
How many vehicles are there?
So I believe there's 3, and then that truck on the second picture to the right, that's his daily driver. That's not what I'm talking about.
Okay.
So it's the Corvette, the yellow Corvette. I don't know what the white car is, that one, and the smashed up truck.
Any other questions? Thank you. You're done with your,
Yes.
okay. Mr. Day, this is your opportunity to speak. You heard what we're doing here. We're looking whether to put a lien on it. It's been here, still in violation, and sir, the floor is yours. Anything you have to share as far as why we should not be putting a lien on it at this time?
Excuse me?
It's your chance to speak to this. We're here due to the violations has brought us to the point where we're about to put a lien on the property because it hasn't been fixed yet. It was found out a violation on the dates that he showed, it looks like December of last year. So do you have anything to present? You don't have to, but this is your opportunity that you want to share with us.
Well, that truck there was messed up.
Okay.
I was driving down the road,
Well, just so we're clear, and I'm sorry, don't mean to cut you off, I'll make sure.
I'll give you a certain time, I'll get it out there. Couple of weeks, I have it all out. I just ain't been able to do it. I didn't have no money to have nobody come and get it, so I had to go to work a couple of weeks to make some money to get it out. Now I got the money and I can get it out of there.
Okay, so.
I'm not gonna make a long story short.
Okay. Okay, so we're here, again, the request is for a $4,800 lien, and then continued $100 a day. He sounds like he's asking for 2 weeks to get it out of there. The violation has already been found, just so we're clear. The fines have been running. So, you know,
Well, is this, when we took this case up in May, the respondent was not here, correct?
do you recall, Officer Adair? I don't recall.
I believe that's correct. I don't think anyone was here.
Have you had any communications from the point of, finding him in violation, or from the point of the initial contact?
So after the initial hearing, I think sometime in June, don't remember the exact date, I was actually stopped by Mr. Day at the Wawa parking lot, and he said he was going to work to remove the truck, and he was going to fix the Corvette. So the Corvette is now on jacks, like lifted in the air, but there's been no additional repairs.
Corvette is being fixed, because that truck on the sidewalk there, that was fixed. The Mercedes is going away, and the electric truck going away. That Mercedes, that's my mom's car, she died in 2008. So I haven't driven it, it's just sitting there.
Thank you. Any,
However, this situation's been going on since last December, is that correct?
Correct, even longer.
Okay.
any other questions or a motion?
I move to accept the staff's recommendation.
Second.
Motion by Mr. Ross, second by Mr. Bates, accept staff's recommendation as presented. All in favor say aye. Aye. Opposed? So that's what we've done, sir. The lien has been imposed. You still need to work on fixing that stuff?
Corvette should be out this weekend.
Okay, well, communicate with him when it's out, and he can, once you get to that point, he can do a notice of being in compliance. Thank you for coming in today, and we wish you the best. We're going to go back. We had two, thank you, sir. Two cases that came in. It is, okay, we'll start with, actually, it's the same respondent. On page 7, case number 24-68 CEB, Carmen Colon and Damie Colon, Wells Fargo Bank, Liz Pendants, 406 Oaklando Drive, Altamont Springs, Florida, 32714. If you're here for that case, please step forward. In the other case, same respondent, same address, 24-69 CEB. It's on the next page, and these will be Officer Adair again. We'll be presenting these.
Do you think we could take a break after these two cases? Because then you have about 6 cases remaining where no respondents are present.
Okay. I'm
Yeah,
sorry.
we need a little break. No, it's okay.
I should be asking him. I'm a guy. I actually got to go to.
They need to get sworn in.
Okay. Folks, whoever's going to be speaking, if you could raise your right hand so we could swear you in, our clerk here.
Do you solemnly swear or affirm the testimony you're about to give is the truth?
And your names, please.
Anna, I'm her granddaughter.
Okay.
What's her name?
Carmen Colon. Carmen Colon.
Whenever you're ready, Officer Adair.
Code Enforcement Officer Cameron Adair, Seminole County Sheriff's Office, South Region. This is case number 24-68-CEB. The respondents are Carmen Colon and Damie Colon. I'd like to submit a copy of this PowerPoint presentation to the clerk as Exhibit A. The violation is located at 706 Oaklando Drive in Seminole County, Florida. The violation charges Seminole County Code, Chapter 95, Section 95.4, as defined in 95.3A, rubbish. The initial inspection was on February 16th, 2024. Notices to respondents were February 27th and October 12th, February 27th and March 12th, 2024. Compliance dates were March 12th, 2024 and March 27th, 2024. Follow-up inspections were February 27th, March 12th, March 28th, April 11th, and yesterday, July 24th, 2024. The results of the follow-up inspection, the rubbish violation remains on the property. This is on the initial inspection, February 27th. You can see the rubbish on the left-hand side in the backyard and on the front yard and the porch.
This is 2023?
Correction, that should be 2024. This is a follow-up inspection on March 12th, 2024. The rubbish remains on the side and on the porch. Follow-up inspection on March 28th. There's been no change. This is a follow-up inspection on April 11th, 2024. The rubbish remains on the side and the porch. And this is yesterday, a follow-up inspection. You can see the rubbish. There's more on the right-hand side, and the rubbish remains on the left and on the porch. The suggested recommendation by the code enforcement officer is based on the testimony and evidence presented in case number 24-68-CEB. It is determined that the respondents, Carmen Colon and Daimi Colon, are the owner of record of property located at 706 Orlando Drive, located in Seminole County, as determined by the property appraiser records, are in possession or control of the property, and are in violation of Seminole County Code, Chapter 95, Section 95.4, as defined in 95.3A, rubbish. It is further recommended that the Code Enforcement Board issue an order for the respondents to correct the violation on or before midnight of August 8th, 2024. In order to correct the violation, the respondent must remove the rubbish from the property. If the respondent does not comply with the order, a fine of $100 will be imposed for each day the violation continues or is repeated after compliance. This concludes my presentation.
Thank you. Any questions for Officer Adair? Seeing none, this is your opportunity to speak to, well, did we have another case? I'm sorry.
She has some pictures, but Damie deceased about 2 or 3 years. She passed away basically 2 or 3 years ago. Damie Colon, her daughter.
Okay.
And she has a picture because when he went by, she was trying to stop him to talk to him, and he just drove off. I know he just had to take pictures and move on, but she wanted her to talk to him, but we have updated pictures from yesterday.
Okay, well, let me,
Can,
one moment. The case he just presented, that's what we're going to talk about now. We're already into that, so I'm going to let you go ahead as it relates to this particular case, what he just presented, and then we'll hear the other one. If you have anything you want to present, you're not going to get it back. It's going to have to be put into the record. And so, go ahead, and I'm sorry, start from...
That's up to date until today. And the furniture that were there and everything, I put it up in the storage with my fiance, so.
And these pictures represent what and what day?
That was literally from yesterday, after he took the picture that he was showing from yesterday's day. That was after the fact that he went by.
Okay. And you're trying to, because, what is it you're trying to establish with these pictures? I still see trash all over.
No, she's working on it. She's like,
Oh, you're
I'm
working
helping
on
her, like literally, she's by herself. My siblings try to help whenever they can. I'm working, I'm a single mom, so I'm like taking care of my son right now. I'm working. When I'm off, I'm like literally helping her there. She's been in and out the hospital for medical issues. So I'm like the only one backing her up right now. But if it needs to be done before the 8th, I will sign whatever to get it done before the 8th. To get it done, because I'm the only one in my fiance that could be a witness as well, that he's helping me as well to clean the house and the front and everything.
So you're good with the compliance date? You're comfortable with that? You see what the recommendation is? Is that?
Ya para el 8, si lo podemos terminar para el 8 de agosto, si Dios mediante. Todo terminarlo, setearlo bien.
Está todo seteado, señor.
Las demás cosas más, todavía falta.
¿Qué falta?
El reguero también el
No, dile que
para
me
el
dé
8,
más tiempo.
¿para cuándo tú necesitas?
Por lo menos que me ponga para el 15 lo que yo junto, chao, para el mes.
She was wondering if until August 15, because she's getting the money to get more stuff out of the house, but she needs like resource. I just used my paycheck last week to just get everything out of until this date. So I didn't even pay my stuff to help her out, so at least till 15 of August.
Why don't you hear the second case?
Okay, Officer Adair, go ahead with the second case before we do this.
Son dos casos.
¿Qué caso?
Vamos a ver el otro. Este es el primero.
Ese.
Este es el segundo.
Está bien, pero ese yo lo voy a mandar a arreglar. Dile que yo lo voy a arreglar.
Code Enforcement Officer Cameron Adair, Seminole County Sheriff's Office, South Region. This is case number 24-69-CEB. The respondents are Carmen Colon and Daimi Colon.
Ah, te lo voy a arreglar.
I would like to submit a copy of this PowerPoint presentation to the clerk as Exhibit A.
Dile que yo lo voy a arreglar.
The violation is located at 706 Oaklando Drive, Seminole County, Florida. The violation charge is Seminole County Code, Chapter 95, Section 95.4, as defined in 95.3E, abandoned or junked vehicles. Initial inspection, February 16th, 2024. Notice to respondents were on February 27th and March 12th, 2024. Compliance dates are set for March 12th, 2024 and March 27th, 2024. Follow-up inspections were on February 27th, March 12th, March 28th, April 11th, and yesterday, July 24th, 2024. Results of the follow-up inspection, the violation of abandoned or junk vehicle remains on the subject property.
Eso mío. Voy a preguntar.
This was taken on my initial inspection on February 27th, 2024. This is a follow-up inspection on March 28th, 2024. And all these pictures, the vehicle's in the same location and operable with flat tires and storage inside. So this is yesterday's inspection, July 24th, 2024. The vehicle's in the same condition. The suggested recommendation by the code enforcement officer is based on the testimony and evidence presented in case number 24-69-CEB. It is determined that the respondents, Carmen Colon and Daimi Colon, are the owner of record of the property located at 706 Oaklando Drive, located in Seminole County, as determined by the property appraiser records, are in possession or control of the property, and are in violation of Seminole County Code, Chapter 95, Section 95.4, as defined in 95.3E. It is further recommended that the Code Enforcement Board issue an order for the respondent to correct the violation on or before midnight of August 8th, 2024. In order to correct the violation, the respondent must remove all inoperable vehicles or store them in an enclosed garage or permitted attached carport. If respondent does not comply with the order, a fine of $100 will be imposed for each day the violation continues or is repeated after compliance. This concludes my presentation.
Thank you. Questions, Officer Adair?
Yes, sir. Officer Adair, is that vehicle's in the same position in that, the photo's taken from a completely different angle? but
Correct,
the
same
vehicle
position, it has not moved.
Any other questions, Officer Adair? Seeing none, this is your chance. We're talking
So
about...
for the car, it's
Yes.
my car, but my mom put a lot of stuff in there. So I'm gonna remove it from the property because, once again, I'm new to everything what's going on. Because I used to live there, that wasn't like that before. So I will take an issue to remove the stuff because I've been looking around to get somebody to remove it, but there's no, I don't have the key, so they're looking for a key. So as soon as it's till the 8th or the 15th, I will remove it within those days.
Está parqueado en mi
No,
casa.
no tiene que moverme.
Thank you.
Sí, porque estábamos, recuérdate, sacando de ahí para de ahí.
Okay.
Entonces meter para acá.
I'll ask you a quick question. Do you think that August 8th, 15th, whether it is realistic? Because I want you to pick a realistic date, and we can,
For the 15th.
okay.
Today is the 25th. I mean, if we did a 30-day,
That's what I was thinking, yeah.
then that would give them until the 25th.
I agree.
So the motion, well, okay, we have two of these. I'm sorry.
Also, I'd like to point out on this case that each one of these violations, the staff is asking for $100 a day here. So if this property does not come into compliance, within, I would say less than 120 days, we're going to be talking about, there's no way that this person would be able to get out from under that level of lien. So I just wanted to point that out before we move forward. In fact, I'll even make a motion. I don't know if you guys will be friendly to it, but
This is not a lien request, just so you know. This is a new case, and it's whether to file them in violation.
right. But those fines will then come to us.
If both violations exist, yeah.
Yeah. Okay, so I'll go ahead and move that we accept the recommendation of staff, except for I'd like to reduce the fines for each one of these to $50 a day instead of $100, with a compliance date of 30 days from today.
I'll second it.
And you want August 25th to be the date we're talking about?
And I second his motion on both of them.
Okay, well, okay. So is there any discussion before we vote on this? Okay, so the motion is to accept staff's recommendation, however, moving the compliance date to August 25th, and the fines on each one of these cases, 24-67 CEB and 24-69 CEB, would continue separately to run at $50 per day if they were still in violation. That's the motion by Mr. Simon, second by Mr. Ross, I believe.
Correct.
And
That's correct.
okay. All in favor say aye. Aye. Opposed?
All right.
I did. Oh, I'm sorry. I missed you. Okay. Okay, so that's what we've done. The board has given you until the 25th of August as requested. Please get it done by then, communicate with
As soon
officers.
as I'm done, but she was wondering, like, when she was trying to wave at him to talk to him, and I don't know how everything works, I'm new with this. Like, she wanted to ask him a couple questions yesterday, but he took off. Like, she think it was disrespectful from his part, from her, being she's an older lady. I don't know, I'm just trying to translate.
I understand. I can tell you, I've never seen him be disrespectful for a second since he's been here, but I'm sorry if that happened. Pick up the phone, call him. He'll give you his number before you leave here if you don't already have it. Thank you so much for coming in. Thanks for the work you've done. We're going to take a short break here.
Thank you.
10 minutes?
Yes, please.
A 10-minute break. It is, what time is it?
4, yep, so we'll start at
Okay.
4 o'clock?
Yes.
Okay.
And-
Thank you. Yeah, we should fill up the form, right?
the record is 401. All right, we're going to start with 3 cases that are on page 4 and 5. The first one will be 24-48 CEB, Property Scholars Investment Group LLC, SBC Startups Resourcing and Enterprises LLC is the registered agent. The property, 138 Anchor Road, Castleberry, Florida, 32707. And the next case, we'll hear them all together since there's no one present. 24-49 CEB, same property owners, same property. And then we also have 2463 CEB, same property owners. Go ahead, Officer Adair.
Code Enforcement Officer Cameron Adair, Seminole County Sheriff's Office, South Region. This is case number 24-48-CEB. The respondent is Property Scholars Investment Group LLC and registered agent is SBC Startups Resourcing and Enterprises LLC. Going to submit a copy of this PowerPoint presentation to the clerk as Exhibit A. The violation is located at 138 Anchor Road, Seminole County, Florida. The violation charge, Seminole County Code, Chapter 95, Section 95.4, as defined in 95.3B, uncultivated vegetation. Initial inspection was on December 14th, 2023. Notice to respondents were on January 4th and January 18th, 2024. Compliance dates were January 18th and February 1st, 2024. Follow-up inspections were January 18th, February 1st, July 12th, and yesterday, July 24th, 2024. Results of follow-up inspection, the uncultivated vegetation violation remains on the property. This is a photo from initial inspection when Officer Henson inspected it. You can show it shows the vegetation over 8 inches. This is my initial inspection on January 18th, 2024.
Could you go back one slide? I believe the date on that was incorrect. 12/14/24?
That's
Oh, in 2023, yes, it should be.
Want to make sure y'all correct those for
Yes,
the record.
ma'am. This is initial inspection by me on January 18th, 2024. The vegetation's still over 8 inches. This is an inspection by me on February 1st. The arrow points to spots of vegetation that are over 8 inches. This is the only photo I have from that day. This is the date of posting on July 12th, 2024. You can see the vegetation around the property still exceeds 8 inches. And this is yesterday's inspection. It's the same thing, vegetation around the property is over 8 inches. The suggested recommendation by the code enforcement officer is based on the testimony and evidence presented in case number 24-48-CEB. It is determined that the respondent, Property Scholars Investment Group, LLC, and registered agent, SBC Startup Resourcing and Enterprises, LLC, are the owner of record for the property located at 138 Anchor Road, located in Seminole County as determined by the property appraiser records, are in possession or control of the property, and are in violation of Seminole County Code, Chapter 95, Section 95.4, as defined in 95.3B, uncultivated vegetation. It is further recommended that the Code Enforcement Board issue an order for the respondent to correct the violation on or before midnight of August 8th, 2024. In order to correct the violation, the respondent must remove all uncultivated vegetation over 8 inches in height. If the respondent does not comply with the order date, a fine of $50 will be imposed for each day the violation continues or is repeated after compliance. This concludes my presentation.
Any questions before we move on to the next case?
Yes, Officer Adair, have you had any contact with this group, and if so, what were you able to find out about them?
I have not, no. I can't speak for Shannon. She is no longer in the room with us. But she was able to, or they called her sometime in between her initial inspection and when I took the case over. And their plan was to demolish the building, and that's the last point of contact. That was sometime in January.
And the building is uninhabited?
That's the next case. I believe people are living in it.
Oh.
Any other questions? Go ahead to the next one.
Code Enforcement Officer Cameron Adair, Seminole County Sheriff's Office, South Region. This is case number 24-49-CEB. The respondents are Property Scholars Investment Group, LLC, and registered agent SBC Startups Resourcing and Enterprises, LLC. I'd like to submit a copy of this PowerPoint presentation to clerk as Exhibit A. The violation is located at 138 Anchor Road, Seminole County, Florida. The violation charge, Seminole County Code, Chapter 95, Section 95.4, as defined in 95.3A, rubbish. Initial inspection is December 14th, 2023. Notice to respondents, January 4th and January 18th, 2024. Compliance dates, January 18th and February 1st, 2024. Follow-up inspections, January 18th, February 1st, July 12th, and July 24th, 2024. Results, the rubbish violation remains on the property. So this is an initial inspection done by Shannon Henson. In the pictures, you can see where the arrows indicate it's shingles from the roof that have fallen off and just remain there. This is on December 14th, 2023. This is my initial inspection on January 18th, 2024. You can see the rubbish remains from the shingles on the left side, and towards the right of the property, there's a shed with all that debris inside of it. It's an open shed. Follow-up inspection on February 1st. The shingles remain in the same spot, and rubbish in the sheds remain the same. This is data posting on July 12th. The shingles remain in the same spot, and in the shed, there's a more clear picture. The debris has changed. This is also the posting from July 12th. This is yesterday's inspection. The shingles remain in the same condition, same location, and the shed has the same as July 12th. The suggested recommendation by the Code Enforcement Officer is based on the testimony and evidence presented in case number 24-49-CEB. It is determined that the respondents, Property Scholars Investment Group, LLC, and registered agent SBC Startups Resourcing and Enterprises, LLC, are the owner of record of property located at 138 Anchor Road, located in Seminole County as determined by the property appraiser records, are in possession or control of the property, and are in violation of Seminole County Code, Chapter 95, Section 95.4, as defined in 95.3A, rubbish. It is further recommended that the Code Enforcement Board issue an order for the respondents to correct the violation on or before midnight of August 8th, 2024. In order to correct the violation, the respondent must remove the rubbish from the property. If the respondent does not comply with the order, a fine of $100 will be imposed for each day the violation continues or is repeated. After compliance, this concludes my presentation.
Any questions?
Officer Dan, this is a violation because the shed doesn't have a door. If it had a door and what was inside would not be rubbish, correct?
Correct. But more so, the shingles scattered across the property. That's just one image in the same spot.
Thank you.
Any other questions before we move to the next case?
Again, this property is occupied or not?
I've never actually seen anyone in it, but based on the debris in the shed, and I know like a homeless population around the area, I believe people are squatters that live in there.
Oh.
There's easy access. Well, the next slide will go into more.
All right, go ahead, continue to the last case.
Code Enforcement Officer Cameron Adair, Seminole County Sheriff's Office, South Region. This is case number 24-63-CEB. Respondents are Property Scholar Investment Group, LLC, and registered agent SBC Startups Resourcing and Enterprises, LLC. I'd like to submit a copy of this PowerPoint presentation to clerk as Exhibit A. The violation is located at 138 Anchor Road, Seminole County, Florida. The violation charge, Seminole County Code, Chapter 95, Section 95.4, as defined in Section 95.3C, remains a rubble of a structure. Initial inspection, December 14th, 2023. Notice to respondents, January 4th and January 18th, 2024. Compliance dates were January 18th and February 1st, 2024. Follow-up inspections, January 18th, February 1st, July 12th, and yesterday, July 24th, 2024. Results of the inspection, the remains or rubble of a structure violation remains. These are initial photos from Officer Henson's initial inspection on December 14th, 2023. You can see, go back to it. You can see on the left picture, it is an open window looking into the house. It's another open window smashed in, and then from Shannon's case notes, I can't speak on her behalf, but she saw the roof caving in. This is my initial inspection on January 18th, 2024. The left picture is showing that the door hanger is still there and the window leading to the inside still open. Same results as the last inspection. Follow-up inspection on February 1st. It's zoomed in, show the arrows pointing to that open window. It's just a darker image, harder to see. This is from data posting, July 12, 2024. The left picture is in the back of the house, showing an open entrance in the back, and this is again the front window leading into the home. So these are the postings for July 12, 2024. And this is yesterday's inspection, July 24th, 2024. So the left slide is just a condition of the house to show you guys what state it's in, and then the right one is that same window. You can look all the way through, see the light on the outside. That's an opening in the door. So it's an entranceway through and through. The suggested recommendation by the code enforcement officer is based on testimony and evidence presented in the case number 24-63CB. It is determined that the respondents, Property Scholars Investment Group LLC and registered agent SBC Startups Resourcing and Enterprises LLC are the owner of record of the property located at 138 Anchor Road, located in Seminole County as determined by the property appraiser's record, are in possession or control of the property, and are in violation of Seminole County Code, Chapter 95, Section 95.4, as defined in Section 95.3C. It is further recommended that the Code Enforcement Board issue an order for the respondent to correct the violation on or before midnight of August 8th, 2024. In order to correct the violation, the respondent must remove, repair, or secure the remains or rubble of a structure. If the respondent does not comply with the order, a fine of $100 will be imposed for each day the violation continues or is repeated after compliance. This concludes my presentation.
Any questions for anyone? Go ahead.
I'm sorry.
Mr. Bate.
I was just wondering how proactive you guys normally are on trying to find this type of respondent. Like Sunbiz will usually have some type of contact and information on entities like this, and then you posted the notice 2 weeks before. I'm assuming you got no response at all from that.
Correct.
Did you try any other methods of trying to get in touch with these people?
I have not, no, besides the initial call, but it is up to them to contact me for compliance.
That's good. That's what I wanted.
I just have a quick question. The structure of that building looks like it might be very unstable. Would you consider that to be a hazard if there is people squatting in there? Is the roof caving in? Would you consider it to be a dangerous condition at all?
I can't give advice on that.
Okay. No further questions? We want to deliberate? We want to talk about what it would look like? We have 3 different cases. We have a vegetation case where there's a $50 fine, compliance, all in the same compliance date of August 8th. $50 for the vegetation, $100 for both the rubbish and the rubble.
I'll be happy to make a motion that we accept staff recommendation in each of the 3 cases we've been presented here.
Second.
So we have a first by Mr. Simon, second by Mr. Bates. All in favor say aye.
Aye.
Any opposed? It passes. So I think our next case is Edward Serapin and Franqueline Lowe, 2466 CEB, found on page 6.
It's got 2 cases.
Oh, there's 2 cases? Oh, okay, sorry. And then the second, and on page 7 will be the second of the cases, same people, Edward Sarapin and Franqueline Lowe, 24-67 CEB. Officer Dare, please.
Code Enforcement Officer Cameron Adair, Seminole County Sheriff's Office, South Region. This is case number 24-66-CEB. Respondent are Edward Sarapin and Franqueline Lowe. I would like to submit a copy of this PowerPoint presentation to clerk as Exhibit A. The violation is located at 207 Grace Boulevard, Seminole County, Florida. The violation charge, Seminole County Code, Chapter 95, Section 95.4, as defined in 95.3B, uncultivated vegetation. Initial inspection was on March 27th, 2024. Notice to respondents were April 3rd and April 18th, 2024. Compliance dates were April 17th and May 2nd, 2024. Follow-up inspections were April 3rd, April 17th, May 2nd, July 12th, and July 24th, 2024. Results of the follow-up inspection, the uncultivated vegetation violation remains on the property. These are photos from my initial inspection on March 27th, 2024. Can you go back to that slide? So, on the left-hand slide, a majority of the next photos are going to be of the backyard and the pool shed. This is taken from the neighboring property. I can see over the fence to look at it. So this was taken on a follow-up inspection, April 3rd, 2024. You can see the front yard was cut, but the backyard remains over 8 inches. This was taken on follow-up inspection on April 17th. The backyard remains the same. This is taken April 18th. The backyard remains the same.
What is that enclosure there with all the growth on top?
What is it? It's a pool enclosure. That's the next case. So this was date of posting. I was unable to see from the neighbor's yard. He wasn't home at the time, and I couldn't observe from any of the surrounding properties. But you can see in the backyard on the left side through the fence, the vegetation remains, and scattered around the front yard, vegetation remains. This is the data posting and a close-up of the front yard. This is yesterday's inspection. It's July 24, 2024. The backyard remains in the same state, severely overgrown, along with the pool enclosure finds on top.
Hold on one second. When you say pool enclosure, there's an actual pool underneath that thing?
Correct.
Okay.
The suggested recommendation by the code enforcement officer is based on the testimony and evidence presented in case number 24-66-CEB. It is determined that the respondents, Edward Sarapin and Franqueline Lowe, are the owner of record of the property located at 207 Grace Boulevard, located in Seminole County, as determined by the property appraiser records, are in possession or control of the property, and are in violation of Seminole County Code, Chapter 95, Section 95.4, as defined in 95.3B, uncultivated vegetation. It is further recommended that the Code Enforcement Board issue an order for the respondents to correct the violation on or before midnight of August 8th, 2024. In order to correct the violation, the respondent must remove all uncultivated vegetation over 8 inches in height from the property. If the respondent does not comply with the order, a fine date of $50 will be imposed for each day the violation continues or is repeated after compliance. This concludes my presentation.
Any questions?
Sir, it does appear from the photographs that someone does live there. Is that correct?
Correct.
Have you had any contact with these owners, and what was the result of those contacts?
I knocked on his door during the initial inspection, but for safety concerns, I did not speak with him. I got back in my truck and left.
And
there's been no contact since.
Okay.
Any other questions? Let's move on to the next case. No water allowed, sir.
I have a question. I can't stand it. I'm going to have to ask. Safety concern, did he threaten you?
There was no exchange of words. He only creaked the door open about 2 inches and wanted me to come closer.
Thank you.
Code Enforcement Officer Cameron Adair, Seminole County Sheriff's Office, South Region. Case number is 24-67-CEB. Respondent is Edward Serapin and Franklin Lowe. Would like to submit a copy of this PowerPoint presentation to clerk as Exhibit A. The violation is located at 207 Grace Boulevard, Seminole County, Florida. The violation charge is Seminole County Code, Chapter 95, Section 95.4, as defined in 95.3F, stagnant water. Initial inspection was March 27th, 2024. Notice to respondents were April 3rd and April 18th, 2024. The compliance dates were April 17th and May 2nd, 2024. Follow-up inspections were April 3rd, April 17th, May 2nd, July 12th, and yesterday, July 24th, 2024. There was also follow-up inspection. The stagnant or foul water violation remains on property. This is a picture of the pool from the initial inspection on March 27th. You can see the green water with all the algae on top. That was supposed to be this year, 2024, not 2023. This is a follow-up inspection on April 3rd, 2024. The pool remains in the same state. Follow-up inspection on April 17th, 2024. You can still see the algae on top of the water. This is from May 2nd, 2024. The pool remains the same. This is data posting. I was unable to get in the backyard, or the neighboring backyard, to see the pool. That should have been a correct date of, that should have been yesterday's inspection date, July 24th, 2024. The suggested recommendation by the Code Enforcement Officer is, based on the testimony and evidence presented in case number 24-67-CEB, it is determined that the respondents, Edward Serapin and Franklin Lowe, are the owner of record of the property located at 207 Grace Boulevard, located in Seminole County, as determined by the property appraiser's records. Are in possession or control of the property, and are in violation of Seminole County Code, Chapter 95, Section 95.4, as defined in 95.3F. It is further recommended that the Code Enforcement Board issue an order for the respondent to correct the violation on or before midnight of August 8th, 2024. In order to correct the violation, the respondent must remove or clear the stagnant water from the pool. If the respondent does not comply with the order, a fine of $250 will be imposed for each day the violation continues or is repeated after compliance. This concludes my presentation.
Thank you. Any questions? So what we have is two cases. We have one for a vegetation violation with a compliance date of August 8th for $50 a day, and a stagnant water one with the same compliance date of August 8th with a $250 a day. Do I have any motions or any discussion?
I move the staff's recommendation in both cases.
I'll second that.
We have a first and a second. All in favor? Aye. Aye. Any opposed? None. Motion passes on both. All right, that's it.
It looked like he had mowed. It looked like he had mowed.
Oh, what is it?
Like he mowed.
Joshua Balls.
Okay, he did mark it. All right, our next case is 2470 CEB Joshua Walls and Sok Heng Cheng, 1904 Heathwood Drive, Winter Park, Florida, 32792. Officer Judges.
Tamara Judges, Seminole County Sheriff's Office, East Region Code Enforcement. For the record, I am submitting a copy of this PowerPoint presentation to the clerk as Exhibit 1. This is case number 2470 CEB, responders Joshua Walls and Sok Heng Cheng. The violation is at property 1904 Heathwood Drive in Seminole County, Florida. Violation charged unsecured swimming pool. My initial inspection was on March 28, 2024. Notice to respondent, March 29, 2024, and 4/19, 2024. Compliance dates 4/12, 2024, and 5/3, 2024. Follow-up inspections 4/19, 2024, 5/9, 2024, 6/19, 2024, and my latest inspection was yesterday on July 24, 2024. Results of the follow-up inspection, the violation of an unsecured pool remains on the subject property. This picture was taken on March 28th of this year, and as you can see, the fence has been pushed down by the vines, shrubbery, bushes, so it does not make the pool secure. This was on 4/19. I was not able to get on the subject property, but the neighbor next door let me in his backyard, so this is looking at it from the neighbor's point of view. On 6/19, I was not able to make contact with anyone in the home or the next door neighbor. I did take a picture of this to show that there was a new fence gate put up, so I was thinking that maybe the whole fence had been taken or had been replaced. However, yesterday on July 24, 2024, when one of the tenants let me in the backyard, as you can see, the fence is still down and the pool is not secured. The suggested recommendation by the code enforcement officer is based on the testimony and evidence presented in case number 2470 CEB. It is determined that the respondent Joshua Walls and Sok Heng Cheng are the owner of record of the property located at 1904 Heathwood Drive, located in Seminole County, as determined by property appraiser's records, are in possession or control of the property, and are in violation of Seminole County Code Chapter 95, Section 95.4, as defined in 95.3G. And it is further recommended that the Code Enforcement Board issue an order for the respondents to correct the violation on or before midnight of August 8th, 2024. In order to correct the violation, the respondents must secure the pool by completely surrounding it by a fence or barrier at least 48 inches in height above the finished ground level, measured on the side of the barrier away from the pool, and where the gates and doors in such barriers are self-closing and self-latching, and where the release mechanism is located on the pool side of the gate. If the respondents do not comply in the order, a fine of $250 will be imposed for each day the violation continues or is repeated after compliance. The respondents must contact myself in order to arrange an inspection of the property to verify compliance. This concludes my presentation.
So is it being rented, or do the respondents live there?
It is being rented. The owner of the property did leave me a message stating that he was going to get the pool secured, and that is what he did. He put a gate on there, which the gate was fine, but did not secure the back area.
And you have, so obviously you've been in communication with the owner?
Yes.
Can you tell me when you did you contact him after, like he contacted you and said that he was going to secure it? Have you spoken with him since?
After my initial inspection, seeing that obviously there was a violation, I made a phone call. The owners actually live, it's either Oregon or Washington, but it's on the West Coast. Left him a voicemail. He called me back. They were on vacation and said he would have it taken care of, and I have not spoken to him since.
Okay.
Any other questions? Any discussion? Then I need a motion.
Motion to accept staff's recommendation.
Second.
We have a motion by Ms. Townsend, second by Mr. Bates. All in favor?
Aye.
Aye. Any opposed? Motion carries. And then we have one more, all right?
I think you're done.
Oh, these, what about these two?
Case is not heard by the board.
And do we have to approve minutes?
No, there were actually some additional changes that needed to be made, so they'll bring them next month.
Okay.
And then just make sure everyone's got August 22nd, 2024 on your calendar. And that's it.
And then I just need a motion to adjourn, unless you want to stay here a little bit longer. Okay, all in favor? Aye. Aye. Thank you, everybody.